35. Why? You are for the respondent. 35. 35 on the request made by the counsel for the petitioner matters referred to magistrate after 4 weeks as prayed for. For admission, orders matter. Orders matter. Okay. 25th. Doesn't matter. When was it filed? Press matters. Okay. Monday. Request made on behalf of Mr. Sharma. After a week. When do you want it? 17. So let it be on 26th. 26th. Admission matters. Let it be in March. 9th of March. Little bit earlier. 25th. I can wait. Start with I during the council. Objection. Counsel for the petitioner does not agree. Fairly. 9th of March. Right. When was it filed? Monday. Monday. Arbitration. Monday. Tuesday. Have to be louder, louder. 30, 31. Want it adjourned. You're for the 7. RMN. ERM. Council for the petitioner. After 2 weeks. 25th. Item 41. Instructions. Counsel for the petitioner, Mr. N.A. Singh, submits that he would like to withdraw the writ petition. Immediately. 2 weeks. Item 9 on the request made on behalf of the DDAR, matter stand report. 9th of March. Yes. Admission matters, 9th March. Item 7. The connected matters, both matters. Then you have to inform the other side. Check the list. There are 2 matters connected. One matter goes adjourned means the other matter will be adjourned. You inform the other side. Go and inform. Yes, yes. What matter? Admission motion. Admission matters, 9th of March. Yes. Why are you proceeding again in view of the order? That's right. Want an interpretation, go and get a clarification. Stage of framing of charge would mean framing of charge. It does not mean that it goes to the stage prior to framing of charge. See, court's orders, judgments will have to be read to give a meaning as it appears. If the court wanted that to a stage prior to framing of charge, it would have said till filing of charge sheet. End of story. Why are you giving this interpretation that till framing of charges? This person giving this interpretation? The gentleman who wants to give an interpretation to the order of the court, please do, but don't proceed in the matter. Heard Mr. H.K. Das, learned counsel to the petitioner, Mr. D. Nath, learned senior government advocate, appearing for all the response. Short period only. The writ petitioner is aggrieved by the yes, you will get your instruction. Where is the impugned order? 5th of December. By which order it was initiated? 5th of December. They agreed that by the order dated 5th of December 2025, fresh proceeding was initiated against the writ petitioner, notwithstanding the embargo by the court by the order dated 5/2/2024 passed in WPC 321 of 2024, the writ petition which was filed earlier by the petitioner, present petitioner. Stop. Era serving as what? Prior to that, respect of a criminal case which was filed, subsequent departmental proceedings initiated. The petitioner approached this court filing WPC 321 of 24, wherein this court had after taking into consideration submission, had passed the following interim order, page number 90. Department has now subsequently issued the order dated 5/12/2025, whereby since the petitioner did not submit his written statement, department has decided to proceed with the departmental procedure drawn up against the so and so, terms of rules so and so. Pursuant thereto, inquiry officer had issued notices directing the petitioner to start the counsel to submits that the departmental proceeding should be stayed till the stage of framing of charges. Connection with the case number. Charge sheets have already been filed. Therefore, the embargo by the interim order will no longer be effective. Private person. Not appeal. As according to the court, as in the opinion of the court, term stage of framing of charges, framing of charges by the competent court. Right. So, charges have been filed, but no charges have been framed on as on those circumstances. What is the status of the earlier writ petition pending? Photo. What was the order? It is in disposal. Provide some clarification, then the same ought to have been sought for from the court by filing a total. Since Mr. Nath appears on behalf of the respondents, 11th of March, 11 or some date later. 6th of March, is the next date fixed. Proceedings in so and so matter. Proceedings in December something. December. It is not convenient for you. 11. 11. 11. Third, Mr. Delivery. Counsel for the petitioner who submits an inspector. Counsel for the stands dismissed on withdrawal. I the rule. First day, terminated, terminated. Appeal also dismissed. What is the finding here? Where is the appeal order? The wrong coding of the rules will not. Force of power is there. He overstayed. Oh, huh? The medical documents enclosed, submitted, while he was on leave, or you were declared to be deserter. That is not challenged. Deserter also. It has to be by a separate order. Desertion has to be by a separate order prior to your dismissal. Who is appearing for the respondent? He is happily in court seats. Call him. Why the matter has been pending from 2013? Why is the matter pending since 13? All right, we'll call up. Yes, Mr. Gogoi. Why did you delay the disposal of the matter since 2013? Huh? Who's responsible? Yes, you're certainly not uh, uh, holding the court responsible.
Penultimate, because there may be some compelling circumstances which might lead to overstaying. Overstaying doesn't mean desertion, man.
Judgment.
This is Coronador Polita from our court, my lord.
Judgment of the apex court.
My lord.
Judgment of the apex court.
My lord, this Christian can't be permanent.
And it is mandatory to have a.
My lord, the rules don't say, but Ram Lakhan Sharma says it is mandatory, because in my case, it was very mandatory because, my lord, it was held ex parte. Had I been there, had I been present there, it would have been absolved. up to an extent. But since my lords, one expert, it was very necessary that the presenting officer should have been there. Because the inquiry officer acts like a judge and the presenting officer is a prosecutor. So every charge should have been open, my lord. Three judges. One is Thornhill Contra. It went to the appeal also and it was dismissed. They were it has held that presenting officer absence of presenting officer is fatal. And the other judgment, my lord, is Ram Lakhan Sharma, where it says it has discussed the whole law, my lord. Though it's not a uniform criteria, but no non-appointment of a presenting officer is fatal. And my lord,
Paragraph.
my lord, which has been thoroughly heard.
Ram Lakhan.
Para 35. 35 and 30. And my lord, 32 and 33.
So Ram Lakhan is not an authority that in every case presenting officer has to be.
In my case, there has to be a presenting officer because
the authority is not Ram Lakhan.
My lord,
Ram Lakhan is not that authority.
my lord, kindly come.
Where are the records?
The record.
You have the record.
Yes, not executed notice. By the principles of Ram Lakhan, we got 35 notice. If the inquiry officer
No, the fact remains that this proceeding cited ex parte in his absence. He has given ample opportunity.
when was he at the relevant point of time? There is no specific testing by the Ram Lakhan subsequently it was a 2012 incident. Ram Lakhan came on notice 2018 notice. So I think the post was issued in 2012. So
we are dealing with the case today. Ram Lakhan is
otherwise, the my lord judgment is there. If the lordship, the situation is adverse to our side, then I am relying my lord one. And my lord, otherwise, lordship, I have the honorable High Court judgment is there. Recent judgment is there. Exactly similar to lordship. Otherwise, regarding lordship, the deserter and absence part lordship, the well settled on I will affect.
What happens? What happened at the appeal? Appellate stage? Appeal. Not prefer appeal.
No. I don't know. I was under impression that there was appeal.
What do you mean you don't know? You are holding the brief.
The brief I am holding, my lord, it doesn't indicate anything as to what happened to appeal. My lord, kindly come to I'll just come to it. My lord, kindly come to page annex 3, my lord, of the petition. No, first, my lord, you come to annexure 1, page 19. This was a memo of charge purportedly sent to me Lordship will find that there is no indication where to attend. Where is the place? Where should I attend?
Come and report to your unit.
Okay. Then
You are posted in your unit, you come back and make inquiries in your unit.
okay. My lords will then come to annexure 2, my lords. So annexure 3, my lord, page 25. Lordship will see the date of issue. 21/5/2012. Whereas, my lord, the
Annexure 3 is a list of documents.
no, my lord, annexure 3 of my petition, my lords, page 25. Lordship got it? I will see the date of issue. In Hindi also, in the translated part also, 21/5/2012. Now, my lords, will come to the second paragraph. 21/5/2012, purported in the issue letter. My lords, see, when they have, by this letter, you are again informed that you are required to be present before the undersigned with regard to your continued absence on 7/5/2012. They are putting the cart before the horse. In the Hindi translation also, I double check, my lord. They issue a letter on 21/5. Ask me to report on a date which is gone on 7/5. This demonstrates, my lords, their attitude. Oh, 21. Fine. ठीक है, sir. I may be wrong, subject to correction also. Maybe.
It appears to the court that you are trying to prepare the case on legs.
No, no, my lord. I'm ready.
You will take it up on Thursday.
No, my lord.
Sorry, Tuesday.
Okay,
Take it up.
my lord.
But you have to explain whether you filed an appeal. If not, why not? Give him an opportunity to go through the records in your presence. Go through, find out. Tell us.
That particular letter which was just shown by my brother was a true fact.
That is subject to correction, maybe.
That particular
What is
letter
the limitation for an appeal?
down. That particular
And even, my lord, the CCS rules, rule 32. A person who is suffering from TB gets a earned leave of 18 months. Just for example, here I was suffering from TB. I have enacted certificate. I was under the care of a proper TB doctor who treats TB. And the other thrust of the argument that the inquiry officer acted like a presenting officer is revealed from the questions he has
We'll take it up in the second half. We will allow him to go to the record.
My lord.
Second half?
taken up some difficulties to person Tuesday or so. I know
Tuesday, all right.
Tuesday.
Based on Tuesday, enabling. He was employed under what? BSF.
CRPF.
CRPF. Otherwise, in the worst situation, minor judgment is also there. I will place.
I place it.
I will place it. Okay. The worst situation from our side, Lordship.
What is that word?
Lordship, then Lordship, it is converted to the compulsory retirement. Then
But he is only removable.
it is removable, Lordship.
He is not entitled to pension.
After High Court judgment, as well as our judgment is there. Our High Court judgment is that part of
But you will have to explain whether principle in Parmar is applicable.
Lordship, I. Please do.
Please, Lordship, just make kindly possible for time being my senior election only for one call. Be that, Lord, be that.
Pass through.
I'll open.
Can this 4 be taken up tomorrow, my lord? We missed out. Our names are not shown.
Monday,
Monday.
Monday or Tuesday. Why is it listed here today on Tuesday?
Fix, my lord. This person is claiming final pension. There are some hurdles, my lord.
You have
He is suffering from cancer.
pleadings are complete. Pleadings?
Pleadings are not wrong.
You filed your affidavit.
No, my lord.
No,
We
no,
have
it's
received
not
only. We only received, my lord, last
Receive
evening.
What?
Affidavit, the instruction, my lord.
File it by next week.
My lord.
Let him file an
Huh?
Let him file an affidavit.
File it by next week.
My lord.
List it on 24th
Then
February. Or you want it later?
No. Here is some urgency. This petitioner is suffering from cancer.
Third, Mr. N. Nath Counsel. Mr. Well learned. Planning Council, Planning Council will respond. Submits that there is urgency in the matter of suffering from life threatening and requires the urgent medical attention. Therefore, pension matter
Pension.
is required to be released. Considering the same, let this matter be listed on 24th of February, by which time it is expected that the respondents will file their affidavit. As per report.
all right.
Last occasion, but to direct state respondent to file affidavit. But the affidavit has not been filed.
Affidavit on what?
On what are the action they have taken on the basis of the direction issued by this honorable court. And there is a violation of the order passed by this honorable court by the authority concerned. So you also wanted to know the status of that. Number one. Number two, my lord, on the last occasion, what my dear friend has argued. The question, my lord, required, there is a gray area here.
What gray area?
My time placing. Okay? If we have got putting publicity your lordship, it has not registered an FI. We have got near superintendent of police your lordship. No action has been taken. If it discloses cognizable offense your lordship.
So your writ petition essentially is for a direction to
Police.
take action by the police.
Police. We are not concerned with land and all. We are not on that.
So respondent, state respondent, what is your, who's appearing for the state here?
Statement, it is required.
Huh?
It is parted by the last occasion your lordship was pleased to mention madam, specific further hearing.
It's not reflected.
It is further hearing, madam. Petition was given.
So the proper.
Okay.
So there is no indication that it will be writ petition wasn't. By which order?
My lord, 29, my 29-1.
29.
Right. In IA, your lordship, it is written there.
For further hearing.
Right.
Matter will require some hearing, and the state will have to give an indication. What have you done?
True. Yeah.
What are your instructions here?
And passport for a time being.
Prayer has been made in this petition for a direction to register the case that police has not registered the case. And the government advocate has informed this honorable court that already case has been registered by the police. And what has been the prayer in this petition? Prayer in this petition is to be in the nature of mandamus directly to responding authorities to register a case on the basis of FIR dated 17/8/2024, lodged by the petitioner number 2 at Risubri Police Station. That order has been already, the police has registered the case.
That is what we want to know.
And the lordship has directed to file an affidavit to the
Right, all right, not affidavit, but at least the instructions be recorded in the order.
Time being.
Who is the hearing here?
Then we had 2 p.m. Begin at 2 p.m.
Okay.
And on 4/2/2010 lordships. It was constituent lordships. At that time, these administrative staff were appointed lordships. Prior to appointment lordship, was publication. And accordingly, lordships petitioners as office assistant, superintendent, and driver, they were appointed lordships. Since then, since 2010, as on today lordship, we are on the fixed pay. All these petitioner lordships, their services lordships. Now lordships, as on their lordships, these respondents, they have not submitted any affidavit. Now lordships, already the petitioners, they have served for 16 years of service lordship. Now
Where is your appointment order?
lordships, case 26 lordship,
Is there a set of rules or bylaws or anything
lordship,
governing?
there is a rules lordship.
Hmm.
Rules, it was published on 4/8/2016
Can we
lordship.
have a copy?
Lordship, I have that.
7.
7, lordship 7, lordship J lordship, 7 J lordship, here lordship is 7 powers and duties of the secretary. That is the headline of 7. And 7 J lordships take up all such matters in consultation with the commission and with their social welfare department, government of Assam, for release of grants, creation of posts, revision of scales, procurement of vehicles, appointment of staffs, laying of annual report, assembly, application of farm, residency.
So who's for this commission now? Who's representing the commission? Standing council is there. Who's the standing council? Standing council, Assam State. Commission for Protection of Child Rights.
I am appearing for 1, 2, and 3.
1, 2, and 3. What is 1, 2, and 3?
Social welfare,
Social welfare.
women and child development.
Now you tell us whether what is the nature of creation of post, appointment of employees under the commission?
Instructions should be required. Lordship.
Why no affidavit has been filed?
Our instruction is awaited, Lordship.
Can't get your instructions, we'll have to call your secretary.
Kindly grant 1 week time, Lordship. I will bring the instruction from 1 to 3.
Inform the senior government advocate that standing counsel is appointed, but presence is required.
Yes, Lordship. No, we are appearing for government department.
You are appearing, but somebody has to inform him.
Yes, I can inform, Lordship.
Who is the person appearing?
I have to take instruction after.
Heard counsel for parties. Petitioner
After week.
is claiming regularization in their posts as what? What are you serving?
Lordship has grade 3 and grade 4.
Grade 3 and grade 4 posts under the Assam State Commission for Protection of Child Rights. Commissioners will actually appointed on contract. Year 2010. Some State Commission for Protection of Child Rights 2015. Bracket 7 within bracket J. Seeing that the secretary to the commission will take up all matters in consultation with the commission. Will take up all matters with the Social Welfare Department, Government of Assam, in consultation with the commission. Then creation of posts, revision of scale, etc. Appointment of staff, etc. So, then council representing the commission is not present. Government council, what the state respondent submits that she has no instructions. Therefore, Mr. Boro appears for respondent number 7. Why is the accountant general required?
Lordship says regarding regulation of
Regularization, their involvement is not there. It's only with regard to pension. You have to be first regularized. What is your claim against respondent number 7? There is no claim against the respondent number 7. Payment of arrear, the respondent 7 is not required. Secretary to the Assam State Commission. circumstances. Some has no role. I amended for studying before we speak. Let's do it thereafter. Meanwhile, please respondent instructors and file their affidavit if so advised. Secretary for the commission complete their instruction, file necessary. 11th of March. March.
But my lord, initially, 7. After his post was my lord upgraded to section assistant in the year 1999, and after his post was regularized on 7/10/2005, my lord. This is at case 23, my lord. I am directed to convey the sanction of the governor of Assam to issue of 500 effect from NCHA zone Haplong as detailed below. As per committee info, the regulation 567 number of workers offered will engage prior to 1/4/1993 and still working in their respective establishment without any interruption or break in service. The list enclosed, my lord. I have filed one additional affidavit, my lord, hearing at case 37, my lord.
Seven.
Pursuant to the order number suspension, the chief engineer PSC Assam Hyderabad, what is the order by dated 7/10/2005, my lord, the earlier my lord order, 91 numbers of workers as per enclosed under the office of the executive engineer, Umrangshu division of Hapu. Umrangshu is brought under the G3 and grade 4 category in regular establishment with effect from 22/7/2005, my lord. And thereafter, my lord, the list, my lord, contain start from this, my lord.
Respondent, why it is not released?
My lord, there, my lord, two numbers of judgment was passed by this honorable court, my lord. In that case, my lord, in Bijon Hafila and Haya Nampur, my lord. They are in the serial number. Everything is same, my lord, except, my lord, in that case, it's, my lord, petitioner is there. After, my lord, my regulation was also cancelled, my lord, which was in item number 12, I have challenged, my lord. In these cases, my lord, that cancellation was a challenge, my lord. And this honorable court was held that cancellation was
judgment is covered by those decisions, but I'm not the main respondent.
Who is for the main
The
respondent?
PhD department, my lord, those two judgments would cover the case of the petitioner. I think no.
Item 13. PhD. April 26, 2006. Some order is not complete.
File my lord, affidavit in this case, my lord, they did not file any my lord such order. By my lord,
Finance and PHE. That order 26.
item number 12, I have challenged my lord. That is 35 my lord.
No, this
Item number 12.
Vijaya
That
Dwalagupu.
is also Vijay Dialogue, my lord. After they have mentioned in their affidavit that order, about that order, I have immediately changed.
Where is that order?
That at least 35 my lord.
This was set aside.
Yes, by these two judgments. But that is not the co-petition only. The order was never communicated. And I have my lord getting salary till my death, my lord.
Councils are not there. We are not supposed to invite them.
I pay for the office of the account.
Mr. D. Sharma appears for the Accountant General. Mr. H. K. Medi for
11:30 time.
okay, 11 and 13. You are for 12.
12.
I'm for 9 and 10.
Mr. A. Chakraborty for 9 and 10. None appears for the PHE department. Item number
11.
passed in coordinate by coordinate benches. And Vikram Hapila
And my lord Haya Manpur.
and Aya Nan, whereby in or circulars were set aside. And however, they don't set aside what I suppose is implement with pension
Provided the proposal comes now. Okay.
by putting up the proper proposal and all the as expeditiously.
There has to be a regular. and-
2012 and 25.
12, five judgment.
Hmm.
2020 is a 3-judge judgment, one pursuit impacts private limited.
In the book list, we have only, for the petitioner, there are only two books, two citations, 2012 and 2025.
6 citations.
Correct. Arbitration Act.
Five, five judge bench judgment, my lord.
Hmm.
There are actually paragraph from 90 to 100. Where I should Section 21 and section 22 refers to section 23 refers to
Section 2021.
section 20 of the Act.
Act.
Of arbitration. Section 20 parties are free to agree on the place of arbitration, which refers to seats. Second, subclause 2,
Failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal having regard to the circumstances of the case, including the convenience of the parties. Subsection 3. Notwithstanding subsection 1 or subsection 2, the arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, for hearing witnesses, experts, or the parties, or for inspection of documents, goods, or other property. This refers to venue, my lord. Is it clear distinction?
Mr. Doctor,
Yes, my lord.
Why can't the tribunal decide on its jurisdiction? Where is there a bar? Let the jurisdiction be decided by the tribunal. Then you see whatever else wants to decide. Why should the referral court be restrained?
The arbitration tribunal to be decided by it, Lord, then it should precede an appointment of arbitrator, right? Now, when the question of appointment of arbitrator comes, then the question of the forum before which the application under section 11 would lie arises. Now, if the section 11 application is maintainable at a forum before which the jurisdiction is otherwise ousted by the clause, then the very appointment of the arbitrator will be impermissible.
One limb of argument. The other is in view of the powers vested on the tribunal itself to decide on its jurisdiction. 16, read with section 20. Tribunal who can decide on its jurisdiction. Jurisdiction need not necessarily be restricted only to the subject matter.
So your question is coming under section 11.
Right.
Now,
Now, if the tribunal, even in spite of being appointed, returns the finding that it doesn't have a jurisdiction in view of the nature of the agreement. But
therefore, my lord, I said, to come to the position of section 16, the provision of section 11 has to be overcome first. Because section 16 will come into play only after the section 11 petition has been allowed and an arbitration tribunal has been appointed. Minus appointment of an arbitration tribunal without the application of section 16 does not arise.
16.
That will be a anomalous situation in my submission, because if the court refers to the arbitration tribunal, then it is otherwise understood and deemed competent to act as an arbitration tribunal in terms of section 11. Now, once section 11, because unless and until the arbitration tribunal comes into existence, the question of application of rule 16 does not arise. Now, the moment your lordship refers the matter to an arbitration tribunal, then it is understood that the arbitration tribunal has come into existence. Now, to bring the arbitration tribunal into existence, Lord, the hurdle of rule 11 has to be overcome first. Now, since it is an application under rule 11, then rule 11 application has to be understood to be before a forum on which, Lord, the parties have agreed to confer jurisdiction by agreement. Section 16 presupposes a position that the arbitration tribunal has come into existence. Now, arbitration tribunal can come into existence only after rule 11 is overcome. Otherwise, Miller, it will be an anomalous thing. Otherwise, rule 11 will become redundant. If, notwithstanding the question of jurisdiction, Lord, if rule 11 petition is decided, then it will be an anomalous situation. After the arbitration tribunal is considered an appointed leader, then somebody takes an objection that the tribunal is not competent for XYZ reason, the tribunal can go into it. But here we are at a stage, Miller, whether your lordship will refer the matter to the, will appoint the arbitrator or not.
Let us go back to the judgment.
Whether the judgment of the Ramani in paragraph 18 and 19.
So let us.
Whether I'll rather read it from para 17. Lord.
No, you have to read it from the.
Yes. Lordship may kindly take up page 465 of the citation.
Yes.
Paragraph 4. Clause
So the issue before the Madras High Court in the judgment and
Yes.
the issue before this court is
same, exactly same.
exactly the same.
Exactly same. Same issue, even the wordings are also similar. The wording of the clause is also similar. Same. Clause 18 of the
Here, 1 minute. Here, where is your agreement?
agreement is page 85, your lordship will find the clause. If I read paragraph 4, Milord, in the Brahmani judgment, clause 18 of the agreement between the parties contains an arbitration clause which reads as under. Arbitration shall be under Indian Arbitration and Conciliation Law 1996, and the venue of arbitration shall be Bhubaneswar. Thereafter, Milord, after the application was filed and accepted before the Madras High Court, Milord, those facts are decided and discussed. And particularly, Milord, the Balco case, about which, Milord, the petitioner's side is also putting stress. Balco case was referred in paragraph 13.
So you have to take us to the judgment properly because
Yes.
jumping from paragraph to paragraph will not
No,
be
Milord.
able to make out what
My
is the
lord,
judgment
I'm just making a reference about reference of the case, Milord. Your lordship will kindly come to paragraph 6 of the judgment. The Madras High
understand the facts, what happened that
Yes. The respondent on 7/10/2016 invoked arbitration clause. The appellant did not agree for appointment of the arbitrator. Hence, the respondent filed petition being so and so under section 11(6) of the Arbitration Act before the Madras High Court on 24/1 for appointment of sole arbitrator. The appellant contested the petition challenging the jurisdiction of the Madras High Court. The ground that the parties have agreed is that seat of arbitration be Bhubaneswar, and therefore only the Odisha High Court has exclusive jurisdiction to appoint the arbitrator. The Madras High Court, by the impugned order, appointed a former judge of the Madras High Court as the sole arbitrator by holding that mere designation of seat by parties does not oust the jurisdiction of other courts other than at the seat of arbitration. The High Court held that in the absence of any express clause excluding jurisdiction of other courts, both the Madras High Court and the Odisha High Court will have jurisdiction over the arbitration proceedings. Challenging the impugned order, the appellant has preferred this appeal. Here also, their contention, petitioner's contention is that it can be arbitration petition can be maintained at either of the places, Noida as well as Gauhati. The counsel for the petitioner submitted that when the parties have agreed for a place venue for arbitration, it gets the status of seat, which is the juridical seat. Therefore, only the Odisha High Court will have the jurisdiction under the Act. The learned counsel submitted that the Madras High Court erred in assuming jurisdiction under 11(6) of the Act, despite Bhubaneswar being the seat of arbitration. In this regard, reliance was placed on Indus Mobile versus Swansea, and Union of India versus Hardy Exploration and other judgments. It was contended that the High Court erred in holding that clause 18 of the agreement does not house the jurisdiction of the court other than the courts of seat of arbitration and arbitration. Learned Counsel submitted that the High Court erred in not applying the ratio of Indus Mobile, wherein the Supreme Court held that in case of domestic arbitration where the parties have agreed at the seat of arbitration, the state court will have the exclusive jurisdiction. By contrast, the Learned Counsel for the respondent submitted that since cause of action arose at both the places, that is Bhubaneswar and Chennai, both the Madras High Court as well as the Orissa High Court will have supervisory jurisdiction. Reliance was placed upon para 96 of Balco versus so and so. It was submitted that, well, that is the exact submission without coming from the other side. That in terms of para 96 of Balco, it should be either at either of the cases. It was submitted that in domestic arbitration, unless the parties tie themselves to an institution of the court in the agreement, here mention of venue as a place of arbitration does not confer exclusive jurisdiction upon that court. It was argued that apart from mere mention of venue as place of arbitration, there should be other concomitant circumstances like use of the word alone, only, etc., or other circumstances. Then only the jurisdiction of the other court, which otherwise would have had jurisdiction, would stand excluded. Taking up to the issued order, the Learned Counsel for the respondent submitted that mere expression of venue of arbitration shall be will have no special significance, and the High Court rightly exercised its jurisdiction under 11(3) appointing the arbitrator. We have carefully considered the submissions of both the parties and perused the impugned order and the judgment relied upon by the parties. As per Section 2(2) of the Act, arbitrations which take place in India are governed by Part 1 of the Act. The court which will have jurisdiction to decide the questions forming the subject matter of arbitration is the court as defined by Section 2(1)(e) of the Act, which reads as under. Then, as per Section 2(2) of the Act, para 1 would apply to all arbitration agreements, all arbitrations where the parties of arbitration is clear. 2(1)(e) of the Act defines court with reference to Part 1 of the Act and would govern the place of arbitration. In Balco, the issue that arose before the Constitution bench was as to whether in international commercial arbitrations, physical or legal seat of the arbitration was outside India, whether the provisions of Part 1 of the Act the applicable grant as held in Bhatia International, etc. Constitution bench in Balco held that if the legal or juridical seat of arbitration is outside India, then Part 1 of the Arbitration and Conciliation Act shall be applicable to such arbitration. And even in case a clause in the arbitration agreement purports to apply Part 1 of the Act to an arbitration where the juridical seat of arbitration is outside India, Part 1 shall be applicable to the extent in process the arbitration law of arbitration. In Balco, the court highlighted the distinction between the seat and venue in the context of 23 of the Act. Section 23 of the Act allows the parties to hold meetings, proceedings, and hearings at any place agreed by parties. In Balco, the court has held that in an international commercial arbitration state in India, parties may, by mutual agreement, hold arbitral proceeding outside India. This, however, would not have the effect of changing the seat of arbitration, which would continue to remain in India. The court then envisages a situation where the arbitration agreement designates a foreign seat and also selects the Arbitration Act 96 as the law of the conduct of the arbitration proceedings. And in such circumstances, hearing of the arbitration conducted at the venue fixed by the parties would not have the effect of changing the seat of arbitration. Para 100, the Supreme Court held as under. Then para 100 is quoted without over this part. Your Lordship can kindly come to para 14. As pointed out earlier, Section 2(1) of the Act defines the court with reference to the term subject matter of the suit. As per Section 2(1)(e), jurisdiction of two or more courts, the parties can agree to confine the juridical jurisdiction to one of the competent courts. In para 96 of Balco, the Supreme Court held that the term subject matter in Section 2(1)(e) of the Act is to identify the court having supervisory control over the arbitral proceedings. The Supreme Court held that the provisions in Section 2(1)(e) of the Act have to be read in conjunction with Section 20 of the Act, which give recognition to the autonomy of the parties as to place of arbitration. The observations in para 96 in bulk pertaining to arbitration governed by part 1 of the Act, where the place of arbitration in India read as under. We are of the opinion that the subject matter of the arbitration cannot be confused with the subject matter of the suit. Some subject matter in section 21E is confined to part 1. It has a reference and connection with the process of dispute resolution. Its purpose is to identify the courts having supervisory control over the arbitration proceeding. Hence, it refers to a court which would essentially be a court of the arbitration process. In our opinion, the provision of section 21E has to be construed keeping in view of section 20 party autonomy. Accepting the narrow construction as projected by the learned counsel for the appellant would in fact render section 20 nugatory. In our view, the legislature has intentionally given jurisdiction to the court, that is the court which would have jurisdiction where the cause of action is located and the court where the arbitration takes place. This was necessary as on many occasions the agreement may provide for a seat of arbitration at a place which would be neutral to both the parties. Therefore, the court where the arbitration takes place would be required to exercise supervisory control over the arbitral process. For example, if the arbitration is held at Delhi, where neither of the parties are from Delhi, Delhi having been chosen as a neutral place as between a party from Mumbai and the other from Kolkata, and the tribunal sitting in Delhi passes an interim order under section 17 of the Arbitration Act to ensure the appeal against such an interim order under section 37 must lie to the court at Delhi, since the court has supervisory jurisdiction over the arbitration and the tribunal. This would be irrespective of the fact that the obligations to be performed under the contract were to be performed either at Mumbai or at Kolkata, and only arbitration is to take place at Delhi. In such circumstances, both the courts would have jurisdiction, that is the court within which the subject matter of the suit is situated, and the court within the jurisdiction of which the dispute resolution, that is arbitration, is located. The above observation in para 96 of the BALCO are in the context that on many occasions agreement will provide for a seat of arbitration at a place which would be neutral to both the parties. In such circumstances, it was observed that the two courts have jurisdiction, that is the court within whose jurisdiction subject matter of the suit is situated, and the court within the jurisdiction of which the dispute venue of arbitration is located. As per section 20 of the Act, parties are free to agree on the place of arbitration. Party autonomy has to be construed in the context of the parties sitting a court which has jurisdiction out of two or more competent courts having jurisdiction. This has been made clear in a 3-judge bench decision in Swastik cases versus Indian Oil Corporation. In the state case, the respondent Indian Oil Corporation appointed Swastik judge situated at Jaipur, Rajasthan as their consignment agent. The dispute arose between the parties as his quantity of stock of lubricant could not be sold by the applicant and they could not be resolved amicably. State matter clause 18 of the agreement between the parties provided that the agreement shall be subject to the jurisdiction of courts at Kolkata. Appellant Swastik invoked clause 18, arbitration clause, and filed application under 11(6) of the Act before Rajasthan High Court for appointment of arbitrator. Respondent contested the application made by Swastik inter alia by raising the plea of lack of territorial jurisdiction of the Rajasthan High Court in the matter. The plea of IOC was that the agreement has been made subject to jurisdiction of the courts at Kolkata and Rajasthan High Court lacks territorial jurisdiction. The judge held that the Rajasthan High Court did not have territorial jurisdiction to entertain the application under 11(6) of the Act and gave liberty to Swastik to file the application before the Calcutta High Court, which order came to be challenged before the Supreme Court. Pointing out that the words like alone, only, or have not been used, and use of such words is not decisive, and non-use of such words does not make any material differences as to the intention of the parties. By having clause 18 of the agreement that the courts at Kolkata shall have jurisdiction, the Supreme Court held as under. In the instant case, the appellant does not dispute that the part of cause of action has arisen in Kolkata. What the appellant says is that part of cause of action has also arisen in Jaipur, and therefore, Chief Justice of the Rajasthan High Court or the designated judge has been considered by the appellant for appointment of an arbitrator under section 11. Having regard to 11(12)(b) of the Act, read with section 20(c) of the Code, there remains no doubt that Chief Justice of designated judge of Rajasthan High Court has matter. The question is whether parties by virtue of clause 8 of the agreement have agreed to exclude the jurisdiction of the courts at Jaipur, or in other words, whether in view of clause 18 of the agreement, the jurisdiction of the Chief Justice of the Rajasthan High Court has been excluded. For answer to the above question, effect of the jurisdiction clause in the agreement which provides that the agreement shall be subject to jurisdiction of the court of Kolkata. It is a fact that while providing for jurisdiction clause in the agreement, the word like alone only for exclusion has not been used. But this, in our view, is not decisive, does not make any material difference. The intention of the parties by having clause 18 in the agreement is clear and unambiguous that the courts at Kolkata shall have jurisdiction, which means that the courts at Kolkata alone shall have jurisdiction. It is so because for construction of jurisdiction clause like clause 18 in the agreement, the maxim expressio unitas est exclusio ulterior comes into play, as there is nothing to indicate to the contrary. This legal maxim means that the expression of one is the exclusion of the another. By making a provision that the agreement is subject to jurisdiction of Kolkata, the parties have impliedly excluded the jurisdiction of other courts, where the contract specifies the jurisdiction of courts at a particular place, and such courts have the jurisdiction to deal with the matter. We think that an inference may be drawn that parties intend to exclude all other courts. Clause like this is not hit by section 20 contract at all. Such clause is neither forbidden by law nor it is does not offend section 28 of the contract act. So this was also this view was also repeated in subsequent decisions, which have been referred in paragraph 15. And then, Millard, the paragraph 17, your lordship may kindly see. The interplay between seat and place of arbitration came up for consideration in India's Mobile after referring to Balco and so, and also amendment to the Act pursuant to Law Commission report so. Speaking for the bench, Norimanji held as under. The amended Act does not, however, contain the aforesaid amendments, presumably because the Balco judgment is in no uncertain terms has referred to place as the juridical seat for the purpose of section 2 of the Act. It further made it clear that sections 21 and 22, where the word place is used, refers to juridical seat, whereas section 23, the word place is equivalent to venue. This being the settled law, it was found unnecessary to expressly incorporate what the Constitution Bench of the Court has already done by your construction of the Act. Whether the paragraph 19, your lordship may speak over and eventually
So, what is the effect of this quoted para 18?
Effective, my lord, if the intention, ultimately, my lord, it is the intention of the parties which has to be gathered from the agreement. If the agreement in no uncertain term refers to a point that the parties had agreed to a choice of a particular place as the seat of arbitration or for all arbitral proceedings, my lord, then it has to be regarded. Merely because the cause of action has arisen at some other place will not be decisive of the matter as to where the section 11 application can be filed. Therefore, yes. We will have now if as in also in this our case, the cause of action has arisen partly in Gauhati. So it can also otherwise have a jurisdiction. But since there is a contraindication in the agreement, so that intention of the party has to be honored. That agreement between the parties has to be honored. And keeping therefore, my lord, in paragraph 18, my lord, where the observation is very specific, where the contract specifies the jurisdiction of the court at a particular place, only such court will have jurisdiction to deal with the matter, and parties intended to exclude all other courts. In the present case, the parties have agreed that the venue of arbitration shall be at Bhubaneswar. Considering the agreement of the parties having Bhubaneswar as the venue of arbitration, the intention of the parties is to exclude all other courts. As held in Swastik, no use of words like exclusive jurisdiction, only, exclusive, alone is not decisive and does not make any material difference. When the parties have agreed to have the venue of arbitration at Bhubaneswar, the Madras Court are in assuming jurisdiction under section 11(6). Since only the Orissa High Court will have jurisdiction to entertain the petition filed under so-and-so, if the order is liable to be. Here also, the clause 18 as is extracted in the judgment, these judgments, that is quite similar to the arbitration clause.
Was that your ground of objection in the notice which was served under 21 for appointment of an arbitrator? But did you respond to the notice served by the petitioner?
Lord may kindly see page 51, annexure B. Dated 12th April. Reference above, bring your kind notice that in compliance of clauses 21(1), 21(1) of the arbitration of general condition of contract, the competent authority at IWA headquarters has suggested the names of the following three persons as arbitrator in the case. So and so, in view of the above, you are requested to select the name of one person from the aforementioned names as arbitrator within 15 days of the receipt of the names to the engineer in charge, and such a person shall be appointed as sole arbitrator by the chairman IWAI as per clause 21 so and so of the contract agreement. The venue of arbitration shall be at Noida.
This judgment was subsequently followed. This Brahmani,
Well, various high courts have, my lord, referred to this.
but no Supreme Court judgment.
No Supreme. I could not find any Supreme Court. But then, my lord, the one of the judgments which the petitioner side has cited, that is Ravi Ranjan Developers, my lord, versus Aditya Kumar Chatterjee. They are also, my lord, the ultimately the decision that has been rendered is upon regarding the clause, and in the clause it was mentioned that it will be the venue. Ultimately, test is this, that if there is a contrary indication in the agreement, then it will necessarily mean ouster of the otherwise, ouster of the jurisdiction of a court which is otherwise available. And in the reply to the to their notice for appointment of arbitrator, also it was made clear at page 51. I have just referred to that. Your lordship can kindly see page 51, paragraph 2. It was made clear that the venue will be at Noida. Page 51 of the arbitration petition. It is in response to their notice. Paragraph 2, your lordship may kindly see. We have given the names of three arbitrators and requested them to select any one of them. And last line, the venue of arbitration shall be at Noida. In my respectful submission, Lord, the inescapable conclusion is that, Lord, the petition before this honorable court will not be made. It has to be filed for a court for which, my lord, the for which and another limb of argument, my lord, that we also have taken in the reply, my lord, the question of limitation. Well, the limitation, well, there can be a situation where limitation can be ignored, my lord, but those situations are not available here. At least the petition also does not indicate that there is any requirement of following the limitation. But on that point, we cited a decision, my lord, that is B and PAG, 24 5 SCC 358. This citation that was given.
Is the judgment?
Well, that is 2024 5 SCC 358. B and PAG versus Ministry of Defense. The basic proposition laid in this judgment is that, my lord, the right to apply for arbitration, that will be the starting point. The petitioners had the right to apply for arbitration not only now, because they initially filed a writ petition before the court. And in the writ petition itself, my lord, we took the plea that the petition is not maintainable. It was 2014, if I am not mistaken with the date. 2014, the writ petition, yes, 2014, the writ petition was filed. And in 2014 itself, we took the plea that the petition is not maintainable. Well, that is 2024 5 SCC 358. Yes, 358. They had filed, well, the cause of action had practically arisen for the dispute resolution in the year 2011. They filed the writ petition in the year 2014. 2014 itself, we took the plea that the writ petition is not maintainable because of existence of an arbitration clause, which eventually gets disposed of in the year 2023, sorry, 24. Now, by reiterating the position that the parties ought to have taken resort to arbitration. Therefore, if the cause of action is calculated, Milord, if it commences from 2011 itself, today after 14 years, 15 years, that it is otherwise hopelessly barred. Knowing fully well if you prosecute some remedy which is not otherwise maintainable, but that cannot save the clause of save the petition. Paragraph. Well, here I will be referring. There are several paragraphs marked, but principally, Milord, I'll be referring to para 34 first. May I read this? Just a minute. I'll start from, instead of 34, start from 31, Milord. Reason being that application of Article 137 is referred therein. Since a petition under Section 11(6) of the 96 Act for seeking appointment of arbitral tribunal is required to be filed before the High Court or the Supreme Court as the case may be, Article 137 of the Schedule to 1963 Act apply. There, well, the 137 is extracted. A plain reading of the aforesaid article would indicate that the period of limitation in cases covered by Article 137 is 3 years, and the said period would begin to run when the right to apply accrues. The starting point of limitation under Article 137, according to third column of this article, is the date when the right to apply arises. This being a residuary article to be adapted to current classes of application. The expression the right to apply is an expression of a broad common law principle and should be interpreted according to the circumstances of each case. The right to apply has been interpreted to mean the right to apply first arises. Here in the present case, Lord, the right to apply had first arisen in the year 2011 when the dispute had arisen. Well, then your lordship may kindly skip to para 36. 36. Case law on the subject. In Inder Singh Rekhi versus BPA, it has been held that the existence of a dispute is essential for appointment of an arbitrator under Section 8 or a reference under Section 20 of the Arbitration Act, and that a dispute can arise only when a claim is asserted by one party and denied by the other on whatever ground. Mere failure or inaction to pay does not lead to inference about the existence of a dispute, as the expression contains a positive element of assertion, and in denying and merely an inaction to exceed a claim or request. Respect to the period of time in the light of the facts of the particular case as to when the dispute actually arises, despite the fact that the contract work in question was completed in the year so, the court observed that even though it was true that on completion of the contract work, right to get payment would normally arise, but where the final bill had not been prepared and when the assertion of the claim was made much after the completion of work and there was non-payment, the cause of action arose from the date when the assertion was made. The court then went on to observe that it was also true that a party cannot postpone the accrual of cause of action by writing letters or sending reminders, but where the bill had been finally prepared and the claim made by the claimant is the accrual of the cause of action. For a proper understanding of the ratio in the aforesaid judgment, introduced here into the para 4 of the judgment entirely. Para 4 reads thus: therefore, in order to be entitled to order of reference under section 20, necessary that there should be an arbitration agreement, and secondly, inference must arise to which this agreement applied. In this case, there is no dispute that there was an arbitration agreement. There has been an assertion of claim by the appellant and silence as well as refusal in respect of claim by the respondent. Therefore, a dispute has arisen regarding non-payment of the alleged dues of the appellant. Question is, for the present case, when did such dispute arise? The High Court proceeded on the basis that the work was completed in so and therefore the applicant became entitled to the payment from the date, and the cause of action under Article 137 arose from that date. But in order to be entitled to ask for a reference under Section 20 of the Act, there must not only be an entitlement to money, but there must be a reference or dispute must arise. It is true that on completion of the work, a right to get payment would normally arise, but where the final bills, as in this case, have not been prepared as appears from the record, and when the assertion of the claim was made on 83, and there was non-payment, the cause of action arose from that date, that is so and so. It's also true that a party cannot postpone the cause of action, accrual of cause of action by writing reminders or sending reminders, but where the bill had not been finally prepared, claim made by the claimant is accrual of the cause of action. It arises when there is and the denial a repudiation of the claim. The existence of dispute is essential for appointment of an arbitrator under Section 8 or a reference under Section 20. There should be dispute, and there can only be a when it is asserted by one party and denied by the other on whatever ground. Mere failure on or inaction to pay does not lead to inference that the existence of the or the request. Whether in a particular case dispute has arisen or not has to be found out from the facts and circumstances of the case. Three principles of law are discernible from the aforesaid decision of this court. Firstly, ordinarily, on the completion of the work, the right to receive payment begins. Secondly, a dispute arises when there is a claim on one side and it is its denial or repudiation by the other. And thirdly, a person cannot postpone the accrual of cause of action by writing letters or sending. In other words, bilateral discussions for an indefinite period of time would not change the situation so far as the accrual of cause of action and the right to apply for appointment of arbitrator.
That's the general purpose.
Yes. Here also, my lord, the dispute first began in the year 2011. They kept on, issuing reminders, letters, etc. And ultimately, in the year 2014, 3 years, they filed the writ petition. The objection was taken at that point of time itself that it is not maintainable.
How is it relevant?
Now, because
Left side.
yes, now if your lordship, that's why, my lord, I am putting this as a second limbo argument.
Fiction is not there. So
Then the question of limitation does not arise.
firstly,
Yes. And if the question, if the limitation is,
we decide that we have to
then this question will come. So in any case, my lord, if the question of limitation, even if it is, assuming for a moment that your lordship would have jurisdiction to decide it, in that view also, that view of the matter also, it's not maintainable because 2011 and it is here in 2025, 26. There are several other paragraphs, my lord. I understand that my colleague has given the reference of the paragraph in the citation. If it is not there, my lord, I'll
I give the paragraph citing. After this Brahmani, tell us whether Brahmani is distinguished. We have it. We have. I have.
State arbitral tribunal shall be at Kolkata. Sitting of the tribunal shall be at Kolkata.
Paragraph, which
Your
paragraph?
Lordship, paragraph 3, last line.
And in your case, the venue.
Venue. As per the Calcutta High Court had stated. The appointment of an arbitrator has to be moved in the High Court, irrespective of whether the High Court has the jurisdiction to decide a suit in respect of the subject matter of arbitration. And with respect to the High Court, all has to entertain and decide. As such, the definition of court in section the High Court expressly of the Arbitration Act to appoint an arbitrator. Time. In application under section 11(6) of the Arbitration Act, for appointment of an arbitrator or arbitration tribunal cannot be moved High Court in respect of the state. Section 11(6) of the Act has the power to suspend High Court. By the jurisdiction of the court. Produce the development of Calcutta High Court is not correct. The parties to Article 5. Very siblings are eligible to benefit and cannot be equated with the or private limited.
So, RD exploration is contra your interpretation.
I feel that because it says siblings are relatable to venue, it cannot be equated with the seat of arbitration or place of arbitration.
City. The seat of arbitration is within the Gauhati.
I argue venue the second argument of the arbitration. Place and the seat of arbitration or the jury has not been decided till now. Therefore, the arbitration venue
According to
or venue cannot be equated to arbitration or private limited. Again, Against me, discussion was in my favor in Brahmani. In this discussion, subsequent judgment. Paragraph 45. Mankastu impacts private limited seat judgment. The seat of arbitration is a vital aspect of any arbitration proceeding. Significance of the seat of arbitration is the applicable law when deciding the arbitration proceedings and arbitration procedure as well as judicial review over the arbitration. The citus is not just about where an institution is based or whether hearings will be held, but it is all about which court would have the supervisory power over the arbitration proceedings. The location of the seat will determine the courts which will have exclusive jurisdiction to oversee the arbitration proceeding. It was further held that the law carries with it the choice of that country's arbitration tribunal. It is well settled that seat of arbitration and venue of arbitration cannot be used interchangeably. It has also been established that mere expression, case of arbitration cannot be the basis to determine the intention of the parties that they have intended that seat as the seat of arbitration. The intention of the parties as to the seat should be determined from other clauses in the agreement and the conduct of the parties. In this case, the development agreement provided that the sittings of the arbitral tribunal would be conducted in Kolkata. As observed above, the parties never agreed to submit to the jurisdiction of Calcutta High Court in respect of disputes, nor did the parties agree upon Kolkata as the seat of arbitration. Kolkata was only the venue for sittings of the arbitral tribunal. It is well settled that when two or more courts have jurisdiction to adjudicate disputes arising out of an arbitration agreement, the parties might, by agreement, decide to refer all disputes to any one court to the exclusion of all other courts, which might, however, by consent, confer jurisdiction on a court which inherently lacked jurisdiction. In this case, the parties, as observed, did not agree to refer the disputes to the courts. Accordingly, the respondent himself approached the district court in Muzaffarpur and not the court in Kolkata. 9 of the Act, respondent having himself invoked the jurisdiction of the district court in Muzaffarpur, stopped from contending that the parties had agreed to confer Calcutta High Court to the exclusion of other. Neither of the parties to the agreement construed the arbitration clause to designate Kolkata as the seat of arbitration. We are constrained to hold that Calcutta High Court inherently lacks jurisdiction to entertain the application of the respondent under Section 11 Act. The High Court should have decided the objection raised by the appellant to the jurisdiction of the Calcutta High Court to entertain the application under 11 for appointing an arbitrator. First, it's very subsequent. Set aside on the ground that order and in view of the objection to his appointment raised by the appellant, and therefore should be appointed by the Calcutta High Court first.
Party approach. File any application under Section 9 at any point.
In the writ proceeding, Lord, we filed an objection saying that the writ is not be maintainable and party should be relegated to arbitration. That has been
Question of jurisdiction was not decided.
no. That was accepted by the writ court and parties were relegated to arbitration.
There is a distinction.
in your list.
Lordship, it's there.
One judgment cannot was left out from my side. For permission. That is, judge of Allahabad High Court. Reputation. Citing the question and taking into account all the precedents on the point. That is here. Whether the citation is AIR Online 2022, Allahabad 583. About this, I also made a reference on a previous date. Just on application of the Sashua principle, then ultimately it is the terms and conditions of the agreement which has to be looked at. If the terms and conditions of the agreement are very clear and unambiguous, then it will prevail over all other situations. But here also, the relevant paragraphs will be the particular positions of the arbitral agreement was considered. The relevant paragraph will be to note the contention. Look, paragraph 12, 13, 14, and 19. That this all dispute between NU and seat, whether these have been taken into account and ultimately the decision. Tenth of March. Yes.
Yep. Today.
Department has passed an order to be free.
Department after this,
Already done.
Reconstruction has been done.
Constructed and my lord. Constructed, we have sent it to my lord, AG, accountant general.
Where is AG? File seeking a direction to the respondent. Update the pension records and sanction all pensionary benefits. Hence, DA. Memorandum issued by the finance. Service book of the repetition. Similar. Process was undertaken and the hard post. Service book in respect of the repetition. There, for accountant general, Mr. B. Sharma, counsel for the accountant general, will obtain instructions as to the status of let this matter be listed 27th of February. Will you inform Mr. B. Sharma?
I will.
You can go.
Right.
Kindly pass over the matter for time being. Additional is the brief Goswami. Header petition announcing. Annex A.
What is your name?
Sanjay Roy. That reply also filed back.
Very report, sir, my lord,
You have furnished an inquiry. But reply, you have a copy.
Yes, sir.
See his reply, para number 1. He said, I have not received the copy of the finding of the inquiry officer. Still received inquiry report not served on him.
Findings. The numbers.
Reply, five. Then 5/25. Then you submit on 10/2/26.
Then, so first notice issued on 10/5. 25.
10/5.
Yes,
Find the reply on 16/5.
16/5.
Saying
And
that I have
15,
not received.
here it is, received copy of findings of DP number 03/2024. Received by Sanjay Roy, date 15/5/25.
Reference to the earlier order of the scope. In so was noted. Same publics before we go. Finding. That's 2024. Submitted by the inquiry officer. Commissioner, and then said application.
There is already a report from the litigant that have made the payment. That report may be seen 5/1/26.
Some other
5/1/26. Then there was 18/12/25. There's a sitting.
see the outstanding amount. You received it. Party said. Creation. Over. 1 minute, just a minute. Some later date, 25th or 25th. Department. Matter. Why you not pointed out? Verify and place it before gift. Matter of dismissal after inquiry.
Yes, sir.
Departmental report. Not admission. The matter by hearing because them in the record. Month of April. Government advocate who is for the government, Mr. J.K. Goswami.
Director of it sent the matter to the undersecretary and I talked with the concerned home department lordship. They stated that they are preparing to send the matter to the governor lordship, or they will by tomorrow lordship. 1 week time lordship.
But without approval, how have you?
For approval lordship, they will send for approval lordship.
Without approval, how?
Power, power is governor. Yes, lordship. Therefore, the department will send the.
Mr. J.K. Goswami. Please begin. 9th of March. Please go on.
How did it form?
27.
7. Had a list of written arguments. Yes, but I have a copy of this. Argument might not have a. Yeah. Third, that issue is already well settled by the both by the civil bank. Lordship, Mr. Arbo Pujari is on his way, Lordship. Lordship may take up. Yes, Lordship. Right. But Lordship.
till he comes here. Second up. Yes. Okay. Perhaps this time. It can be get the order. Why if it is covered, why to keep it like this? Might take time. 17. All right, 17. None represents the petition. Mr. By an order passed by the appellate bench. Brings for some time to place the order. Accordingly, let this matter be listed on 16, 17 of February. Thank you. Yes.
Your Lordship, kindly adjourn his matter.
Why?
I senior is not available.
Who is your senior? A. Chakravarti. For the government. Submit. Request made by the council hearing for the petitioner that by 26.
Next week, we have so many matters take up, so.
The 2015 matter.
Yes, Your Lord.
Huh? Ask your senior to be present. We are accommodating him. Don't stretch your indulgences. We are accommodating you for today. 2015 matter, 11 years. Dismiss it if you are not interested. Let it be on 16th. Sorry, 17th of February. Yeah. Yes.
34 matter large stoppage and notice was issued. Now,
you-
through a reliable source, I have come to know they are in receipt of the notice. Document feeds this on Wednesday. I'll try to take instructions whether they are willing to.
Why should we stretch it? We dismiss it. If he is interested, he'll come and file applications. Yeah. 511, you are given liberty.
Otherwise, because there shall be appropriate course, because even if it's allowed also,
Hmm.
his dismissal was modified to compulsory retirement. Perhaps it will matter, Mr. Burden.
Mr. D. Gogoi, Learned Counsel. It's that he is
Fine.
petitioner in spite of efforts. Petitioner has also not made.
M. Burma.
submission made that stand dismissed for non-prosecution. The interim order is written stand.
How like?
Passed over for the day.
I see record. Producing records is directly to the
Tell us when you want it. Well, all right. Mr. U.K. Goswami, learned CBC, submit that is seat of the record, but if for the time. Therefore, submits that matter be deferred and fixed again on 12th March. Comes into action.
There's a preliminary record. Xerox copy also. I don't want to keep the original with me, Malad. It's
Your record,
again, I'm get it on by before 12 months.
you do whatever you want to do. We have not, reports are not as yet produced before the court. So you take it, you turn it to do whatever you have to do, but we are
On
fixing
12,
it on
it will
12.
be readily available for all.
It is
I'll
very
have-
clear that the records pertaining to the case should be made. Right. It's now medical health, your health.
Little bit is looking for.
Have you, are you attending to your work?
Yes,
What is the diagnosis you are suffering from?
mental anxiety.
Mental anxiety. Oh. Don't want to be transferred.
Oh,
Come back at 2. Yes.
That's it. I come to the core issue on my grievances of the transfer order. Let me show a little bit of the background. That's it. I have joined in the respondent bank on 13/7/2013.
Is there a bank policy with regard to transfer?
Yes, there is a bank policy.
Is it available?
Yes, she has annexed.
We have annexed.
Where is it? Where is it?
Policy is in 38.
38. Yes. What does it say regarding transfer?
The violation is 3 counts, Lordship. Come to point number 4, page 42.
Yes.
Page 42, Lordship.
Yes. Number 4.
Number 4. Female officer employee shall be tried to transfer as far as possible to the nearby places, stations, region in case of their transfer to a place where their husband, parents are stationed, or as near as possible to that place, or vice versa, based on the availability of vacancy and so on. That's it. Here I'd like to mention the order dated 29/10/2020 of this court. The last page, the observation of the court was that last page of the order, second paragraph. However, on the question of whether the petitioner can be accommodated in nearby station, as per the clause 4 of the transfer policy and guidelines under the heading Common Guidelines of Transfer, the learned standing counsel submits that he would like to obtain his instructions. But in the reply affidavit in opposition of the respondent bank, nowhere it has been mentioned what instruction has been taken from the bank and whether she can be accommodated to a nearby station. And this is a clear violation of the transfer policy of the bank. This is first.
Where were you posted earlier?
Not it, the sequence is that I have joined in the respondent bank way back in 2013. I initially joined at Golaghat branch, then I was transferred to Narikalpuri branch, and 2016 I got promotion. I joined in officer assistant multi-purpose cadre, which is a clerical cadre. Then I have been promoted to officer in 2016. Then I have been transferred to Gauhati branch under Gauhati region, and I joined at Gauhati branch of Gauhati region on 10/8/2020. Then on 29/4/2025, I have been transferred to Gauhati regional office. Then again on 5/5/2025, again on 15/10/2005, by impugned order, which is in page number 21, I have been transferred to Golaghat region, Gonapuri branch of the Golaghat region. So where is the violation, Lordship? I have already mentioned that the point number 4 of the common guidelines of transfer that has been violated, and board observation was that it should be looked into. That has not been done. Now, second point, Lordship, point number 2, page number 43. No officer shall remain posted in the same capacity position for more than 3 years. Normally, officers will not be rotated, transferred before completion of 1 year. Lordship, I have joined in Gauhati Regional Office on 6/5/2025, and I have transferred after 5 months by the impugned order, which is in page 21. So this is a clear violation of the transfer rules adopted by the bank. Lordship, I would like to point out one very important point. The bank, Assam Gramin Bank, is a regional rural bank established under the Regional Rural Bank Act 1976. It is a central statement. And this policy has been framed
under the direction of Government of India. In fact, Government of India has 50% share over this bank. Rest 15% is the state government.
What is the stand of the respondents regarding the adherence to the policy? What have they stated in their affidavit?
They have failed to come out with any cogent reply. And before that, Lordship, I would like to point out the third violation. Third violation I would like to point out, which is point number 6 of page 43.
Yes.
After posting to tenure, that is 6 years in one region, officer will be transferred to other region. Head office will be considered as a region for this purpose. So, to tenure, that is 6 years. And I have joined in Gauhati region on 10/8/2020. And I am due for transfer after 6 years, that is 26. And for completion of the 6 years mandatory period, I have been transferred. Lordship, being aggrieved with the transfer order, I have submitted a representation before the general manager of the bank and the grievance redressal committee of the bank. As per policy, there is a grievance redressal policy which should sit at least once in a month regarding the transfer related grievances, and the decision of the grievance redressal committee was never communicated to me. And meanwhile, I have been released from the released from duty to join at Ganaputri branch. Then and there we come to this court and obtain a stay order.
Where are you posted now?
He is posted here by virtue of the stay order. She is working in the Gauhati regional office. Lordship, now I would like to point out how the grievance redressal committee has dealt the matter. Lordship, kindly come to para 7 of the affidavit in opposition, page number 48.
That is not challenged in your petition. Grievance redressal order, you have not challenged in your petition. You are only challenging the transfer order.
We are challenging the transfer order, but that yes, during the grievance, that because we have not been communicated. We have not communicated of the grievance.
Then why are you referring to the grievance redressal order?
No, because they have mentioned that grievance has been duly redressed. In fact, grievance has not been duly redressed.
Then you'll have to challenge it if you are aggrieved.
Lordship, that is come by virtue of their affidavit only, that they have come to the they have disposed by representation.
Where is the grievance redressal?
Grievance redressal is Lordship is page number 55.
55.
Lordship, grievance redressal here, page number 55 of the affidavit in opposition.
So you have been communicated now.
Not communicated. Lordship, you see, kindly see whether from this grievance redressal sheet, my reply is specifically mentioned in para.
Mr. Counsel, you are questioning this grievance redressal council, the order or not? Are you aggrieved by this order?
Main issue is, Lordship, violation of the transfer policy.
So let us not go into the grievance redressal because you are not challenging it. You'll have to challenge it, and they'll have to be given an opportunity.
But, Lordship, I thought that I should point out the perversity that has been committed.
But perversity, illegality, irregularity, you will have to first challenge it. You will have to make it a part of your pleadings. According to you, you were not aware. During the course of the pendency of the writ petition, the affidavit was filed, grievance redressal order was issued. Now you are aware. During the pendency. Now
that is also violation, Lordship.
Whatever violation, but you have to challenge that.
Yes, that is there in our pleadings, Lordship. That is there in our pleadings.
What is there? Yeah, respondents, what do you say?
But the order of the Bristol committee basically describes the reasons why the petitioner.
There are no reasons
Yes, ma'am.
discernible.
The remarks are there, ma'am. Annexure A, page
55.
yes. The remarks are there, ma'am. We have considered the grounds that which she has.
Where are the remarks?
The right hand side.
Uh,
Hearing almost 6 years in Gauhati region, selected on sorting by highest duration in the region, adjusted due to relatively excess manpower in Gauhati region and requirement due to extreme deficit in Golaghat.
but what do you do with your transfer policy?
Transfer policy, my lords, yes, there is a transfer policy and
Number four.
normal circumstances, my lord, we would have gone by the transfer policy.
What
But
is the abnormal circumstances here?
not abnormality, my lord, but there are certain aspects. My lord. Issue is that transfer order
Is it punitive transfer?
no, it is not a punitive.
Not punitive transfer.
Because there is nothing against her as such.
Very well.
Now,
So
Golaghat
why
region-
don't you follow the clause 4?
Plus clause 4, let me say, the Golaghat region is the original home region of the petitioner. It is not an unknown region. She was appointed first there. She spent from 2013 to 2020. She was in Golaghat region in the Golaghat district. 2020 to now 2026, about almost 6 years now, she is in the Gauhati region. Yes, she has been shifted from one branch to the head office, but the head office is now having surplus number of offices.
No, she
Now-
was not her any purpose.
Anyway, she was very much within the Gauhati region. So his case is that since she was the regional office or the head office is a separate region, so she should be retained here. Now the question is that very much she is within Gauhati region for last 6 years. Whereas in the other region, even in her home district only, we are facing deficit. But ours is basically a rural bank. And she has been transferred to a rural branch. But that rural branch happens to be in her home district. And a transfer order, lordships are aware. The transfer policy is basically an administrative guideline, doesn't have a statutory force.
You will have to give all these materials to
Yes,
show that there is excess number,
Yes, we have
These
given.
people
We have
not
stated the reasons.
and at least this should have been considered by the redressal committee. This one line dismissal doesn't explain anything.
Grievance redressal committee was more than these reasons. These are not really the nature of quasi judicial orders. In my humble submission.
We are not asking for justiciable reason. We are only asking the. See, now you are an officer. You are a counsel for the bank.
Lordship.
Without instructions, are you able to tell us what is the reason for dismissal, the rejection of this?
No, that is why we have placed the GRC order also, and the affidavit has also.
That's right. So what we want to tell you that this order, you have rejected somebody's representation. There is just a single line, no explanation.
No, this is
Now
the
the case you are building up that there is excess manpower,
Yes.
there is less manpower in Golaghat. All these things will have to be available
For that,
somewhere.
You would have to get the specified data, but whether let me make out.
You have already filed an affidavit.
Yes, that is.
This
This is the
doesn't contain
affidavit.
the data.
In my humble submission is not required because he has to make out that I have violated a statutory provision because that is the law.
Then what is the fund in having a transfer policy?
Because the transfer policy is
Why?
a-
Is it
yes,
because
it's
somebody
it's a guideline. It's a
No,
guideline.
so why make a guideline when there are no statutory mandates regarding transfer?
There is no statutory mandate. It's a
Then,
guideline.
According to you,
we do act.
unless it is mandated by a statute, guidelines are only advisory. So why would you give an advisory you have no intention to follow?
No, it's not that we have no intention, but
Then-
in order to have a legally
Is it
enforceable
because
guide-
somebody was sitting idle and had nothing to do? Therefore, prepare a guidelines, circulate it.
No, these guidelines have been issued by the RRB.
So you take a call and say that under these circumstances, these guidelines are not applicable. Have you
No,
taken that?
in the case of the petitioner, strictly not applicable.
Who decides?
No, that is
Who has decided that?
the grievance redressal committee.
Where do
and
you get
the
it from?
competent authority.
Where do you get it from?
That
Show us.
reasoning, my lord, is not there in
Then-
GRC's order.
then-
It's a transfer, my lord's order.
So,
Reasons, my lord,
then why are you following these policies? Why have you not scrapped these policies?
we do not have that.
You do not have this power. That means you are
But we
bound
do
to
have
follow
the
it.
power, my lord, in my humble
Bound to
submission.
follow it. Unless you
Lordship,
must
can be
know
heard. Lordship,
that
can be heard.
under a given circumstances, this policy is not applicable. Where is that reason?
Lordship will consider one thing. These are in the nature of guidelines. Because it's not that we cannot deviate from them. That is what the law says. The law
You are
permits these
blowing hot
deviations.
and cold. On one hand, you say these are not prepared by you, but by central authorities. Therefore, you have no power to scrap it.
No, we cannot
On
scrap
the
it.
other hand, you are saying that you're not bound to follow these guidelines.
We can occasionally deviate from
Under
this.
what law? Under what rules of the bank?
Look,
Was-
because if we follow each and every, part
Have
of
you
the
taken, as a
guidelines-
board, have you taken a call that these guidelines, we cannot follow it in each and every situation?
Because in my
Or
humble
in
submission,
cases where situation demands, we should be permitted to
Because we
deviate from
kindly
the
have
guidelines?
para 12, para 12 of my affidavit, page 51.
Para 12 is an explanation
Yes, it's an explanation.
of
That is what we have
of the
said.
guidelines, which doesn't reveal the explanation.
No, that is what it has been stated on affidavit, that the transfer policy does not prohibit a transfer within
This
5
is your
years.
explanation
Yes.
of a particular policy taken by the
Because these are enabling
adopted by the board, and
Yes.
which the policy does not itself reflect.
So the policy,
Mohinder Singh,
policy is basically, an enabling guideline. It's not a disabling guideline. We are not prevented from it. But if I may just rely upon the division bench judgment of this court, that even the violation of the transfer policy will not lead to interference.
question is not whether violation of a transfer policy
Yes.
is fatal or not. The question is, why have you deviated? What are the reasons? What are the reasons?
Yes. The reasons, my lord, in my humble submission are reflected in the affidavit taken along with the GRC.
Affidavit cannot supplement reasons. Must be available from your records.
Then perhaps the lordship will have perhaps
Are we
ask us
supposed to
take a-
invite you to supplement your affidavit with relevant record? We have given you time to file your affidavit. You have filed it.
No, my lord, in that case, because what would have happened thereafter, that the three from the
You have taken an administrative decision to transfer somebody out.
Yes.
Is it because of your whims and fancies?
No, no,
Because
it
you are a
cannot-
higher authority?
No, it cannot be. That is why
Then,
the GRC
then
has
you
said
have a
the
policy.
reasons.
You have a policy that you must give a reason that it is under these circumstances that we are required to deviate from
No,
this policy.
I need not say any more reason than administrative exigency, my lord. I have
Why?
a surplus of
What
officers here.
is the administrative exigencies?
That I have more officers here, my lord, and I have less officers.
Where
in
are
here.
the data to show that,
data,
to justify
my lord,
it?
So this nature, perhaps then I will have to file an judicial affidavit. So then, my humble submission, my lord, this is not a quasi-judicial order. Transfer
Maybe
orders
the
are-
time has come now for the court to restrain respondents from filing affidavit and directing the concerned officers to be present in court with all relevant records, so that we save time. We have given you opportunities to file an affidavit. You choose what goes into the affidavit. You are the counsel.
Gotcha. Well, the data then would have to be, but well, this in every case,
Has to. Every case that comes before us, we'll have to see it on the facts.
But my argument is that the transfer policy. Let us say, for instance, accept that there has been a
We'll
deviation.
record it. Mr. Counsel, be careful. We'll record your submission that this policy is not binding. And tomorrow when somebody comes and says that this policy has not been followed, your reply would be that this policy is binding.
Ordinarily, my lord, it would be definitely binding. Because in a given case, my lord, however, we can deviate from.
What are the grounds that permitted
The grounds
you
is that,
to deviate?
The grounds is that paragraphs 14 and 18.
Show us the data.
Paragraphs 14 and 18. She has said, I am a psychiatric person. Question that fell even before the other bench, where the matter was heard, is that whether she is even a fit person to continue in service. That apart, we have not considered that. We have only said that she has spent 6 years in this region. Look, she cannot claim to be continue indefinitely.
That's all right, but you explain this para 4.
Which paragraph?
Para 4 of your policy, that in cases of female officers.
Yes.
Then?
No, Lordship will kindly consider female officers employees shall be tried to transfer as far as possible.
Right.
No, that as far as possible
Has
gives
to
us
be
the leeway.
reflected from your records that you have tried, but it was not possible. Therefore, you have transferred.
But that may be very difficult. And as far as
Why
possible,
is it difficult?
Because,
Somebody in the bank has to apply their mind.
we
Therefore,
as-
first you take a call
the-
whether these policies are applicable or not applicable.
these policies are applicable.
Applicable.
They are guiding.
So if they're
principles.
applicable in a given case, you have to deviate. Somebody has to apply their mind to say that these are the facts on which we have deviated. We have a wrong reason. court may not accept your reason, but there must be reasons.
Gotcha. As
Can
far as
you
the
just say
data-
that, no, these policies are not binding? Who are you to say that?
No, that is not our standing. That
Hmm.
cannot be also.
Hmm.
The question is, Manoj, that whether the deviation is permissible. The deviation is permissible. And even if I deviate, Manoj, that would not be a ground to interfere with the transfer.
That will come to later. First, you satisfy why you have a policy
Or
which
the
you have
other-
no intention of following it.
If I may suggest, perhaps an opportunity may be given to us to pass a detailed order.
No, you show us the reasons. Why should we? You see, what you are giving them, why do you want the court to give you another opportunity, give you a bigger ball to them?
But
You show us the reasons.
my additional affidavit will also be a bigger ball.
Counsel for
I'll place the data.
Mr. E. Ganguly, standing counsel for the bank, submits that you would like to file the affidavit containing and place relevant records showing the reasons as to why the policy regarding the policy of transfer, more particularly regarding female officers, could not be adhered to in the facts of this case. Let these affidavits be placed on record within 4 weeks.
But
Yes,
lesser time maybe. I'll file it within 10 days.
2 weeks.
But you will have it after 2 weeks.
2 weeks.
On a
Matter
date
be
fix.
listed after 2 weeks.
But there's an interim order.
Interim order passed early will continue.
But you will have it on a particular date.
Based on 18 March.
But okay.
On other days, I have something that to act is they were solicited, he was solicited under CCS rules, and other is FR 56J. But my friend started from the first one, but my senior came and started from the bottom, my lord. It is bad.
What is bad?
My lord, the order was passed by this commissioner bench in 6016 of 2020. Not where my lord, the antek. I tried submit, but I could not.
Yes. What is the effect of this order?
Well,
What do you want to show from this order?
because my lord, on the day I could not, but pair is there that the petitioner, the petitioner, pairs was shown to your lordship, my lord,
Hmm?
because 3769.
Why have you placed this order?
Because it is depend upon the outcome of WPC number 3769 and 5054 of 2000, filed by regular director, earlier director.
Regular director is a question of his superannuation.
His superannuation,
Then-
but during the interim order, my lord,
Hmm.
he passed the
He passed. Then subsequently it was reviewed by the
reviewed
officiating
by the
director.
officiating director.
Then
But it is depend upon that. In my
how is it
consideration,
dependent?
depend upon whether the first order was valid or not.
Assuming the first order was not valid, then the subsequent order is already there on record. And their challenge to these orders is that this could not have been passed without the approval of the Secretary of the Health, Central Health.
There is no provision in the FR 56 Act but because the appointing authority is bound by the
Yes, Mr. Fugon, what do you say?
Under the total district case is now number 15. Here,
See,
my lord,
your challenge is number one, that the director who had passed was not in the office at the time when he issued this order, right? Subsequently, the court granted liberty to review that order. Review was made and the same earlier order was, same order was
Same
passed. Review was done by this officiating director, which means that it was not by the officer who had earlier given the, namely the director, right? Second is, you say that these orders by director or officiating director are not valid because there is no approval by the secretary. There is no approval because according to you, you are central government employees. You are unable to show us that the employees of the institute have been brought within the fold of central government. Where is that notification? Merely because you are receiving gazette salary equivalent to any central government department doesn't make you central government employees.
they are not gazetted official. The,
Wait, let him come. We'll see. We'll pass on notes. Yes. Yes.
So as per order dated lordship, 10/2/2026 lordship,
Mm.
where RP Sharma sir, council lordship, submitted lordship for the respondent number dispose of the numerous representation which
Yes, government, who's there for the government? At MS Council, the next one, so Council for the petitioner. Your prayer is a direction to dispose of the representation. The petitioner was appointed as a constable on 25/4/1984. Subsequently promoted to the post of ASI Police within Brigade Wireless. Stopped during the course of his employment. Petitioner fell sick on 28/7/2019, and he was shifted to Silchar for better treatment. There he underwent the required treatment from 29/7/2019. So he was subsequently declared medically fit to resume his duties with effect from 27/10 to 2020, along with medical certificates and medical papers, and rendered his service till date of his retirement on 31/8/2023. Stop. The petitioner submitted several representations before the respondent number 3, along with medical papers, in praying for sanction of his leave on medical ground for the period he was on leave, which is 4, 5, 7 days, and to pay his salary for the aforesaid leave period. Stop. However, despite the petitioner approaching the respondents, specific orders have been passed. Stop. Better. The respondents number, the respondents have filed their affidavit. Mr. Das, you are appearing for the state in this matter. Who is appearing here?
I'm here for civil 5.
Who is for civil bench 3 government council?
I'll just.
The respondents have contested the case of the petitioner by filing their affidavit stating that in spite of notices being issued, the petitioner did not turn up for attending his duties. He had the habit of borrowing money from the local people. He also took loan from different banks by submitting false documents where the signature of the guarantor is has been forged. The aforesaid actions were not befitting, and therefore a departmental proceeding was drawn up against him under Section 65, the Assam Police Act 2007, read with Rule 66 of the Assam Police Manual, Part 3, and Article 311, the Constitution of India, read with Rule 7 of the Assam Services Disciplinary Rules. In the departmental proceeding, the show cause notice was issued, but he was at his home address, he was found absent, and his whereabouts were not known. The petitioner was thereafter directed to submit his reply to the show cause notice within 10 days, which was an advertisement to that effect was published in the Assam Tribune and Dainik Juwa Samkhok in their issues of 2009-2019 stock. However, no reply or any communication in respect of the show cause notice has been received. Stock. Thereafter, the respondents appointed an inquiry officer and as also a presenting officer. Stop. The inquiry proceeded ex parte as the petitioner, in spite of notices being issued, did not participate in the inquiry. Stop. The inquiry officer concluded the inquiry, and the disciplinary authority, upon considering the conclusions or findings of the inquiry officer, having regard to the evidence in the record, provisionally decided to award petitioner with punishment, withholding 2 annual increments with cumulative effect. Stop. Thereafter, the show cause notice, a second show cause notice issued. Submit, they're giving an opportunity to the petitioner submit any reply against the proposed punishment penalty. Stop. The said show cause notice was also not replied to, and accordingly, the department proceeding was disposed of by the department authority, awarding the punishment of withholding of 2 increments with cumulative effect. ID order dated 30/01/2020. Stop. The respondents have always also stated that the petitioner was absent, was unauthorizedly absent for a period of 457 days, which is in violation of the relevant leave rules. And he was therefore granted 457 days leave without pay, regularized his period of absence from 29/07/2019 to 27/10/2020 by the DO number 1135 dated 16/12/2020. And accordingly, his pay was kept under seal. Was thereafter released. Petitioner thereafter joined his duties on 27/10/2020. Stop. It is also stated that after regularization of his period of absence of 457 days of leave without pay, his salary was regularly drawn from the month of December 2020. And the period 27/10/2020 to 30/11/2020, his salary was also drawn by the salary bill raised dated 11/1/2021. In view of the claims raised by the petitioner that he was medically unfit. Medical bill board was constituted by the Joint Director of Health Services, Kachar Silchar, and upon due examination, it was found that although he suffered from conditions like diabetes mellitus, from a hypertension, etc., for which he was under treatment from the local physician, Kumar. There is no finding of the medical board that he suffered from psychiatric illness.
Yes.
And therefore was found to be medically fit to attend his regular services. The respondent therefore did not grant medical leave, say, as because he was found to be medically fit and not suffering from any mental illness. The petitioner so filed is going to reiterating his claims. Have you challenged the departmental proceedings or the findings of the medical board anywhere? Is it under challenge? The findings of the medical board that he was found to be medically fit to attend to suffer medical illness. Such circumstances, this court does not find persuaded, except the prayer of the petitioner that the representations filed has not been disposed of. So, in view of the specific finding by the department imposing punishment pursuant to departmental proceedings initiated, which proceeded ex parte to the non-participation of the petitioner in spite of notices issued, and which proceedings have not been challenged, and the findings of the medical board regarding the petitioner being found fit to attend to duties. Direction to the respondents to dispose of the representations such circumstances. Finds the dismissed, no other as to cost. Dismissal of the petition, however, will not debar petitioner from pursuing his claims at the appropriate forum, if so advised.
Deeply obliging.
Earlier directed to give the grant report. Business grant report. Due to non-business grant report, his pension, his gratuity and remuneration was held up. Lordship is
Vigilance to be issued by whom?
Chief Vigilance Officer.
Of
Lordship can see page 97 of their affidavit in opposition. Para 4.
97.
Para 4. Issued on 2013. The duty of vigilance can furnished by the vigilance of for
You are referring to 94.
97. Para 4. Page 97, para 4.
Yes.
The duty of vigilance can furnished by vigilance for any purpose in respect of all employees shall remain valid for 2 months. The affair department need not seek fresh business clear in which response employee for purpose before expiry of 2 months, like suspension. During the period, if any adverse come on notice, business clear having bearing to guidance stipulated, same shall be communicated to HR department. So, and in this case, they have not extended the vigilance clearance, though it is 26/3/2013, only 2 months.
What benefits are due to?
Leave encashment and gratuity.
Yes.
Lordship will please have page 93, which is the same vigilance circular.
Yes.
Para 1, requirement of vigilance clearance. Vigilance clearance is required to be obtained for the following purpose. Clause N, releasing of final dues, withheld payments of the employees, including retired employees. Clause M, superannuation, resignation, etc. Lordship, thereafter, these vigilance reports are valid for only 2 months. These reports for all of these 3 petitioners were obtained. Lordship will have page 98. That is the vigilance report in case of petitioner number 1. He did not get a clearance, Lordship. This was issued on 9/12/2016. Thereafter, Lordship will have page 100. This is with respect to petitioner number 2. This is again 1/3/2017. And thereafter, Lordship will have page 103. This is also the denial of vigilance clearance to petitioner number 3. And this is also, Lordship, dated 11/12/2023. Our stand, Lordship, is that this vigilance report is a dynamic document. Depending on that particular time, it may change. So, Lordship, at this stage, if they approach the corporation, we can obtain a fresh vigilance report, which will take into account the status of the trial, the CBI case, etc. And then it may be that if in case there
If
are no
the trial has not concluded, you will say that the salary should not be released, then?
Lordship, otherwise, internally, this is a vigilance circular is applicable. So, without that being obtained, it is not possible for the corporation to release it.
There is no rule in NEPCO to end up the gratuity and leave encashment.
No, it says vigilance regarding your retirement benefits, etc. is there. Final payments. Therefore, do they offer you pension?
No, not a single.
Then
For last 20
releasing of
years,
final dues, withheld payments.
for 9 years, he has retired. Since 9 years.
But the report is against you.
Yes, for 2 months only. They,
2 months it is valid. Then they will require again re-verification. to find out.
that have not done.
They will let them do it. You want us to close the petition or keep it pending?
I know actually leave encashment is a part of salary. Should be released.
Lordship, one other aspect.
And Honorable Supreme Court is very clear that
What is due from them? Only leave encashment.
leave encashment gratuity.
Gratuity.
One other aspect is that the third petitioner has not approached the corporation with a representation. If they perhaps come, we can consider with a fresh vigilance report.
They've already rejected first and 2. Well, like, this is the judgment, Lordship. Honorable. Dependency or it is another judgment.
Paragraph number? Which paragraph?
The first party.
Huh?
Holding the part of salary.
Which paragraph?
Judgment.
The judgment you have given us?
Yes.
Which paragraph?
Page number, paragraph 19. Jagdish, Saini and others. What is opinion that therefore reasoning the binding the conflict regarding entitlement appearance the claim of grievances ban? Just argued the virtue of Rule 5 of 2020 and
There is no para 19 here. It's only up to para 16.
that context.
You are referring to para 19 of the judgment. This judgment contains only 16 paragraphs.
No, this is the
This is
Jagdish
state of
Prasad Saini.
Jharkhand versus Jitendra Kumar Srivastava.
Yes. This para 30.
This judgment has only 16 paragraphs. Para 33 is quoted judgment. Read para 33. This matter again next week, enabling the council to address the courts, perusal of the place the relevant case laws. You come back prepared. What is the point if you are not prepared to give a date?
Suffering my daughter.
They're suffering because you are not prepared to do the case. If they're suffering, you should be ready to tell us what is the issue, which judgment, which paragraph.
Date will be
Date will give you 17 March.
earlier.
Not available. Dockets are filled up. 17 March.
First week of March.
First week is not possible. You can take 12th of March, we'll see. There are 10 matters fixed, but we'll see. Why are the other two matters connected? I don't see there any connection. Challenge made by the director.
Director has challenged his
So
retirement.
why is it connected here?
No, it was initially thought of because that they have some relation of his plea taken there, and we are saying that he doesn't have the authority. He says, no, I have authority, I have raised certain points. But subsequently it was realized that's why it was segregated.
So what are your grounds?
So my
Num-
ground is
Number one, that the director was not competent. He was already
already resigned. And thereafter he passed the order, number one. Second, that 56 day, they have given the age limit there. I do not come in within those parameters. Not just say what it says, my lord. It has the book.
Yes.
Says 56J, notwithstanding anything contained in this rule, the appropriate authority shall, if it is of the opinion that it is in public interest so to do, have the absolute right to retire any government servant by giving him notice of not less than 3 months writing or 3 months pay
and announces in view of such notice. Then one, this is the I come out with this. If he is in group A or group B service or post in a substantive, quasi-permanent or temporary capacity, and had entered government service before attaining the age of 35 years, after he has attained the age of 50. First requirement is it can be applied to a group A or group B officer, provided he has joined the service, he has entered the service before 35 years of age, and he has now attained 50 years. In what is not applicable to me because I joined in 42 and now I'm 55. They applied me in 55. This provision to me when I'm 55 years old. So this
So
means
in number two,
number two, in any other case, that means not the A and B group, other group officers, in any other case, after he has attained the age of 55 years.
so in any other case, the first rider of 35 years is not there.
Not there. But in any other case, we have to understand in my responsible submission, an officer not belonging to group A or group
B. Which group do you belong to?
I belong to group A.
What are group A officers?
Group A options is that this first one.
No, what group A constitutes of which officers?
B director. There are
From-
rules.
From where do you say that?
At the under the this recruitment rules 2003, that what will take up their volume.
Recruitment rules.
2003. There, project may come to internal page 7.
File also. File also. पहले फाइल लगेगा ना the old branch here. Bring it. Yes, recruitment rules.
Yes. Yeah, internal page 7, my lord, down below the page number.
7.
That page, Doctor will find name of the post at the top. Associate professor, psychiatry. Number of post 4. Whether selected post or selection. Classification A, medical. Group A, medical.
No, it doesn't say group A. It
Well,
says A medical.
A, medical.
Ah.
Is indicative of the group. Their
So it's not
class.
indicating. You can't proceed on presumption. There must be a classification specifically. These are group A officers. These are group B officers.
One of the specific.
Has to be there. How do we interpret it that you belong to group A or group B, or you don't belong to any group A?
Probably other side also not belong to group A.
Yes, where are the recruitment rules?
Group A, scale of
Group
classification is
Group A.
Group A, but
Okay.
it is not the semi-government cadres. Semi-government cadres.
Do you agree or disagree with the submissions made?
They are A group, my group A.
The query of the court is, do you agree with the submission or disagree?
Agree, my
Agree. So if you agree they are Group A, this Group A is relating to these rules. So they must be considered to be officers under Group A in respect to these rules, not as per your recruitment rules.
Yes.
Have you been able to understand?
As per my recruitment rules.
As per your recruitment rules, they could be A to Z.
Yes.
But question is, we are trying to see whether these FRSR, this Rule 56J, number 1 is applicable or not.
Not
For how can you say that on one hand they are Group A and on the other 256J they are not applicable?
Because we have recruitment rules and
Then why are you saying they belong to Group A? Vis-a-vis the rules. If you say they are Group A vis-a-vis the rules, then 56J1 is applicable.
Recruitment is not as per the semi-government.
So why are you making irrelevant submissions? We are asking you a pointed query whether they are in Group A so far as Group 56J is concerned. Your answer has to be yes or no. You say yes, they are Group A, and then you say no, if they are not Group A in terms of 56J. What is the meaning of that?
Group A, official, my lord, I admit.
Group A, under these rules.
Yes, as per my rules, my lord.
We are not concerned as per your rules, whether your rules reflect the position under these conduct rules.
Conduct rules is applicable.
Where is that list which shows Group A? Group A and Group B, where does it show? You come to these rules, 56J. Show us, where are the Group A officers?
Yes, my lord.
Where is the list?
My lord, as we adopt this fundamental rules, my lord, and 56J is mandatory. Fundamental rules is mandatory.
You have not understood the query. I'll repeat it again for your benefit. Please come to Rule 56J. Do you have a copy of the rules? Sir, Mounto, have you been able to find the group? Group A list, Group A and B?
Yeah.
Recruitment rules they mentioned, but in reference to 56J, for you to apply,
Yes.
you'll have to draw a connection between these rules and 56J.
That case, you have to go to control civil services, transition control and appeal. Yeah,
Yes.
yeah. Yeah, that is fine. Central Civil Services Transmission Control Appeal Rules 1965.
Hmm.
Rule 6 table.
6.
Classification of post. Civil post under the union, other than those ordinarily held by persons to whom these groups apply, shall by general or special order of the President be classified as follows. Central Civil Post Group A, Central Civil Post Group B, then CD. Now, kindly come to sub-rule 2. There is a
Sub-rule 2 of
two of the rules.
Rule 6 of CCS, CCA rules. There is no sub-rule 2. This was substituted on 75.
Matlab the this
Subsequent amendments have taken place.
matlab this notification comes one guiding principle for classifying Government of India's orders under Rule 6. Hereby directs that with effect from the date before issue of this order, all civil posts under the union shall complete by general or special order made from time to time be reclassified as Group A, Group B, and Group C, and Group C, as it may be indicated below. And that government order they have classified, they have shown. Plus one, A, Group B, C. But earlier it was shown as classified as plus one, plus two, plus three, plus four. And then revised classification as Group A, Group B. That is the change they have brought in. And there they have given table, the table, description of post, classification of post. One side will be here. There is a several civil post carrying a pay or a scale of pay with a maximum of not less than rupees 1300 rupees. This is the basis of the payment. So 1300 and more. It comes with group A. 900 but not less than 1300 but less than 1300 then comes to group B. This is how they have classified. This Lordship may in my book this book. Classification they are accepting. In the other pages also in other aspects they have told group A, group B in this recruitment rule system.
CCS.
And his pay band, but now he is drawing. Earlier also he was doing now he is drawing the pay band 37,400 plus MPA.
Yes.
Another, my ship has said that from the internet they have found that now that 1300 has come to 13,500.
So if you are a group A and you enter at the age of 42.
35. Before 35.
35. Before
Yes.
35.
Before 35. Then this is, and I am attaining 50 years. In that time, then they can apply it to me.
Where is that order?
It's good, madam.
Hmm.
First order, also can see.
Hmm.
First order is that the A77 after 20. Definition 6016.
First order.
At the page 77 and excerpt 20. Order dated 17th September 2024.
77.
77.
77 is the
It
end
will
of the
be-
affidavit.
Prohibition 6016.
016. Why 6016?
Because this is second institution file challenging the so-called reviewer.
So cause
Reviewer.
review. Page number
Page number 77.
77.
It says, but the date is 17th September 2024. Whereas the appointing authority is of the opinion that it is in the public interest to do so. Now, therefore, in exercise of the powers conferred by Clause J of Rule 56 of the Fundamental Rules, the competent authority hereby retires Dr. Dhruvoditi Setia, Associate Professor, Secretary, with immediate effect from the afternoon of 17/9/2024 on completing 55 years of age. Now, definitely, it says 55 years of age. I am above 50. Dr. Setia will be paid a sum equivalent to the amount of his pay and allowances for a period of 3 months, calculated.
Are you relying on any judgments in support of your contention that 56A, 56J1 is applicable?
Well, I look for, but there is nothing specific on that. There is otherwise.
You want to say that if these two conditions are not satisfied,
That
there is no scope for 56J.
Exactly.
There is no scope to include you under Roman
2. Now it appears they have included me in Roman 2. 55 years they have shown here in this order. But this is not applicable to this order, Proceedingsy in 17.5 order, 17.9 order. They have said that they, with immediate effect from after so and so on completing 55 years of age. This 55 years is affected in case of other officers who do not belong to A or B group. So obviously, they could not have applied this to me. And here, what people can be, see one thing. Central government issued a office memorandum how to proceed in such cases, 56J. That lot people will find it page 83 for the time being lot people can be used. Here, it is dated 30th of May 2016. This subject strengthening of administrative periodical review under FR 56J and Rule 48 of CPS pension. And they have quoted first para, they have referred to, and then second para, they have quoted 56J. And then logic will find they have also said under FR 56 appropriate authority who is has been defined as the authority which has the power to make substantive appointment to the post or service. Then when we come to next page, it is column 2. The provisions under FR provide for retiring a government servant on completion of 50 years of age in case of Group A and Group B officer, and on completion of 55 years of age in the case of Group C officer. Rules 48 of the CCS pension rules also provide for retiring a government servant on completion of 30 years of qualifying service. Therefore, what you will see, they have also categorically explained it that this for A and B, it should be applied on completion of 50 years.
Yes.
So my small submission is this order itself, from that point of view, day one, I come in and I do not conform to these requirements, and they didn't apply that, they applied to 55 years, so this is not applicable to me. And therefore the order is that beneficial on that. And apparently, the older bands, while first hearing this matter, was of the tentative view that this order cannot sustain, it is prejudicial to me. Therefore, recorded, kindly see at page 80. The order starts. Plus WPC 5114/2024, the first restriction of it, when it was I will read from page 80, Madad. Fifth para. After hearing the learned counsel. After hearing the learned counsel for the parties, it appears that there is substantial confusion as to whether the respondent who was holding the post of director of LTDRI.
So this we say that even assuming, firstly you want to say that notwithstanding the stay order obtained by the director, that order was with regard to his superannuation but not fitted to the office of the director. Therefore, it will not apply to the office of the director. And as a consequence of which, the officiating director subsequently appointed. So therefore, even if
Therefore-
the first order is incorrect, liberty given by the coordinate bench for the review, which was undertaken by the officiating director.
I have a little submission here. The review was asked by this honorable court to do, otherwise they do not have the power to review administrative order. Relates to this order, dated 17/9/2024,
Page number?
page number 77. This order was asked to be reviewed. Prima facie being satisfied that the court says a prima facie opinion that if the impugned order dated 17/9/24 is allowed to stand in the present form, in that event, the same may cause serious prejudice to the interest of the petitioner. More so, since the normal age of the retirement from service of the employee of so and so under rule is 65 years. Because otherwise I will retire at 65. I am 55. They have retired me by applying a wrong provision. Therefore, court was the prima facie view that it will cause serious prejudice. Therefore, you review this order. In my respectful submission, to my understanding, this means that this order is not tenable in law. You review in the sense that you withdraw it. You withdraw it.
So much of interpretation can be read into an order of the court.
Well, can you see?
And the
Otherwise,
court
they do not have
recorded a prima facie.
prima facie. Prima
And,
facie.
and the writ petition was also disposed of.
No, it is there.
It was pending.
It is pending. Now, it is before your lordship, it is there. It is there.
Now we'll take a
So-
conclusive view.
Lordship will take a conclusive view now. Now, what I am trying to make out is, if an order is initially bad, the review order will be equally bad.
If the prima facie view that
No. Lordship will, for the time being, give aside problems. Lordship has seen now.
no, if we hold that 56J is not applicable, then the review order, everything goes.
Go.
There's nothing wrong.
Yes.
The question is your argument that the first order, the director is not competent. Second order also is not competent because this is a review. This is a review of the earlier order,
Yes.
which was issued by an officer not competent. But that I may have some difficulty accepting because it was an officiating director appointed by the appropriate authority.
True. The director has undertaken this process of review of the alia,
Right.
17/9. 17/9. And
So,
then,
so therefore, on the ground that since that order could not have been passed by the earlier director and therefore bad, further review is not going to sanctify that order. That is your ground.
that subsequent order, maintaining that order, review, had it been something else, leaving aside that,
Review does not necessarily mean that the earlier order has to be changed. It's a review.
no, that
May
is
change, may not change.
not true. But then what my submission was on the basis of the prima facie view of the court. The court, that's indicative enough that this is prejudicial order, because other submissions are still there. I am not going to.
We have to understand that the court was of the view that perhaps 56J was not applicable, so they will review it instead of us going
Yeah.
into and setting it aside.
Look into it again.
So that not having been done, now we are seized of the matter
Exactly.
here and pass order.
True. Malak, otherwise, this is one leg of my argument. Secondly, it is here also, can you see the review order at page 82? In compliance to the provisions of the periodic review of so-and-so 56J, order of the Gauhati High Court, so-and-so 33/10/24. The matter has been reviewed and appropriate authority, that is the appointing authority, is of the opinion that it is necessary to retire the government servant in public interest. They have invoked the public interest. Now, therefore, in exercise of the powers conferred by Clause J of Rule 56 of Fundamental Rules, the competent authority hereby retires Dr. Jubadi Sethi as the professor to effect from the afternoon of 17/9/2024 on completing 55 years of age. Say, 55 years of age. So and so has already been paid some equivalent to that of 3 months notice, showing them immediately before this retirement. This is issued as per direction of the Ministry, Video Communication dated 4/11/2024. Now, here referring different 4/11/2024. Is issued as per direction of the Ministry, Video Communication dated 4/11/2024. Also, you will see that communication 4/11/2024, page 7676. Yesterday, I closed 24. Therefore,
676.
six. Our affidavit we have annexed it.
Just a minute. Just a minute. Yes. 7.
7. Oh, 676.
676.
7.
This is what?
This is the communication dated 4/11/2024, which has been
No,
referred to.
This is 30 September 2022.
The additional affidavit, madam. 016 is file additional affidavit.
67.
676.
676. 676 is
Annexure 20.
page number 731 in the board scope.
Don't check. 6016. 6016.
That's right. 4/11/24 is written by the Undersecretary
Written by the Undersecretary. Ministry of Health.
regarding 5114.
Yes, yes.
This is page, this is number 731. Doesn't matter, please carry on.
Yes. Just to the director. Subject WPC 5114/24, University Setia and others, no High Court. Because High Court asked them to review. So in that context, they wrote it and they have replied it. This is with reference to WPC show and show, 5114/2024, titled as University Setia. This has challenged the order dated 17/9 issued by the director LGB hiring the petitioner, that is Dr. Setia, on attaining the age of 55 years, effect from 17/9/24. The Honorable High Court of Gauhati in WPC 5114/24, titled as Dr. Subhajiti Setia and others on 3/10/2024, copy enclosed, has passed an order directing that the order dated 17/9/2024 may be reviewed by the respondent, and any order passed may be brought on record by filing an affidavit. It is pertinent to mention that the Honorable High Court of Gauhati WPC 769 of 2024, titled as Solendra Kumar Deuri versus Union of India, he filed this present time, and others had on 37/2024, copy and close, passed an interim order that the superannuation that shall be stayed. The stay order was only operating to the services of the petitioner and not confined to the post of director of the LGBRIMH. The Learned Council of Ministry of Health and Family Welfare has opined that the order dated 17/9/2024 passed by Dr. Sulinder Kumar Deori is not a valid order. He did not have jurisdiction under the law to pass such an order, and the same is not sustainable in the eyes of law. Therefore, the authority of Ministry of Health and Family Welfare, Government of India shall review the order dated 17/9/24 as per the observations of the Honorable Court with the order dated 3/10/2024. In view of the above, the order dated 17/9/2024 becomes an order passed without any authority and institute is directed to take necessary corrective action. Compliance of court's order.
That's all right. They have given an indication. They have
Therefore,
issued it.
yes. Now, we have also said that this is not tenable in law. It is to be fact ordered in the reviewed in the sense Health Court has directed.
Item number 5 and 6, finally. If it will be, it's gone for vetting, it will be read tomorrow morning. Can it be taken up on next week?
So only question I was
Status, but
troubled is whether we should have it or we should let it come up before the appropriate bench file.
yes, ma'am.
Hmm?
Yes, ma'am. Yes.
Was it part heard?
Partnered, ma'am.
All right, you file it.
Can it be taken up on Wednesday?
Wednesday. Wednesday. 5 and
5 and 6.
5 and 6. Wednesday. Is that all right? Wednesday. Or 11. 411.
Because that was referred to in the own order.
But that's okay.
Submission. That, that is, and you take corrective measures, that would mean that the order should be withdrawn. That would that is this normal meaning.
That we will record it, but we prima facie we don't see how that can be interpreted. The order of the court and the advisory issue does not say that you withdraw it. It says that you review the order.
Corrective court says they have asked opinion, central government has said that it's corrective. And take corrective measures. Because this is
If you show us some authority to say that in these circumstances, when a review is directed or resorted to, it must mean that the review is done to make the necessary corrections. If you have any authority in support of your contention that review in these circumstances must mean that the review is done only to correct the error.
error. Something.
That's all right.
But exactly, Lockheed has that is the point I was corrective measures. Not to repeat the same order again. Because it is virtually repeating the same order. Some of still. Therefore, order, the threshold is not liable to be acted upon and cannot sustain the of course.
Yes.
This storm
Hmm.
is the government who controls and manages that is what I going with it. I mean, change it to society, and it was taken over by NEC, but finally it was taken over by the central government, the Ministry of Justice, and there was an agreement. There's part of subject, there's part of the health and safety. The undersigned is directed to assume welfare and and any and whereas hereby agree. And take over the control and management of the all very specific. Management and take over the control and management all over and taking over of the effect from 1,007. Five, four. The general character of the institute shall be maintained. Matter of and autonomy of that figure. Maintain the autonomy of the care management structure. There is one body, governing body, and one executive council. That's what they are. The recommendations of the committee constituted under the chairmanship of all proposals for acquisition, organization, function, and by
You come to second page, serial number 6.
yes. First, for the take all rules, everything.
No, no, come to second page, serial number 6.
Yes, all proposals.
No, no,
Affect the
second page. Previous page.
whereas therefore we should have positivity support. Once 2007.
Budgetary support.
Budgetary support will be given, but also the control and management of the all assets and liabilities. This is the every term.
Correct. But nothing about the employees.
Nothing employed the effort and everything comes to them, but what I find, what is right, I take the connection with my idea submission. Because what is happening, I have to, yeah, yeah, everything. Because this was in 2007, this equipment was in 2003. And the constitution is of 91. Thereafter, nothing is complete has come. But what remains factual, the director still working or being allowed to work the appointment. But he should take approval. Because the whole management and control is the central government. Fund also maintained, therefore he takes the approval. That is the control there.
That was never taken.
That was not taken. That was not taken. In my case, first also, they have not taken approval. And second time, they have referred to 4/11/2024 as an approval. But this is wrong. It's an approval to maintain the earlier order, 79 order. Am I correct, madam? So, this 4/11/24, in fact, not the approval of the earlier order. They have to take corrective measures, but they maintain the same order under the signature of the officiating there. Therefore, it's another illegality committee. Another illegality committee, the order back. besides the fact that I did not come in within that age, joining 435 years and attaining 50. They are applying 50, 55 years, which is under 2. They 2. And it is officers below the pay. Therefore, it doesn't apply to me. Now, second point would be, if at all this review is done, who has done this? Right? But the earlier order was also passed by the director. Second order is also maintained by the director. What is the review?
Sure, some authority.
Therefore, I
Yeah.
approve submission. Order doesn't reflect anything, just these are the considerations, considering all that.
You have to base your submissions on some authorities to show that when there is a review, there must be consideration of these
Yes, yes.
gamut of facts which was not done.
Therefore, officer can come to have another document of this government, which is subject, page 89.
What is the date? What is the date?
8 August 2016. Here the instruction with individual review.
Indications are different, so it is difficult to.
My petition, I read
Yes.
that
Yes.
yeah, government employee for strengthening of administration under Fundamental Rule FR 56A1 and Rule 48 of the CCS Pension Rule. says, as para, instructions have been issued from time to time for undertaking periodic review of performance of government servants with a view to ascertain whether the government servant should be retained in service or retired from service or premature in public interest as per fundamental provision rules but to subject cited above. In order to bring the better clarity to the existing instructions and enable uniform implementation, an effort has been made to review, consolidate, and reiterate the guidelines so far issued on the subject at one place. Yeah. The Chennai over the as is 56J, next is 70, they refer to 56J, and then logically speak will go to 91. Position of review and presentation committee. Follow it, madam. Composition of review and the concerned secretary of the cadre controlling authority CCA will constitute a review committee of 2 members at appropriate level as under. In case of officers holding group A post, review committee shall be headed by the secretary of the concerned CCA cadre controlling authority. Where there are boards, namely Railway Board, Postal Board, Telecom Communication, etc., the review committee shall be headed by the chairman of such board. Now, our case, we take that they are going through their own, that old law, erstwhile law, which was framed in 1999, which needs to be changed, but they have not done it as yet. Here, administration, they are following, they are maintaining. So, first is the Board of Governors is there, and then Constitutional Executive Council. The chairman of the Executive Council, the Constitution document will keep over the first 2 pages, then kindly come to the next page. Logic will find clause 6, Constitution, the Board of Governors. There, the next page, all representatives, all government officers, all government officers.
Why is this reference necessary?
Because in case of, here in this guideline, I have read out, in case of boards, they say, otherwise, cadre controlling authority, secretary shall be the chairman of the review board, review committee. At page 91, last clause, in case of officers holding to pay post, review committee shall be headed by the secretary of the concerned CCA, that is secretary of the Ministry of Health and Family Welfare. Where there are boards, they may say that we have the boards. So, in that case, they say, in that case, boards, the review committee shall be headed by the chairman of such board. Now, if you see what is the chairman of the board, chairman of the board as per their constitution is the secretary of Health and Family Welfare. at page 9, my lord, clause 9, Lordship. Clause 9. An executive council of the society shall be constituted to manage the day-to-day business and affairs of the society as an institute the following members and functions. Secretary, Health and Family Welfare, Government of India, Chairman. Vice Chairman is the Secretary, North Eastern Council law. Members are all these government officers, all government officers. Superintendent, these are all government officers. Director is the member secretary. Is the member secretary. Director is the member secretary. Last 116. Therefore, it doesn't conform to this requirement also. Because they are following all the rules, instructions coming under the central government. We say that since no new laws have or amended laws have come forth, that will be their law will be applicable to the extent it can be read. Therefore, this review Lordship has seen once more, 5th November 2024 at page 82, is done by whom? The competent authority is the appointing authority. First paragraph itself. Page 82. Appropriate authority, appointing authority is of the opinion that it is necessary to retire the government service in public. And second paragraph they say, therefore, in exercise of the power 56J, the competent authority hereby retires Dr. So. And last line they say it is issued as per direction of the Ministry of Communication dated 4/11/2024. In fact, my lord, this letter 4/11/24 reflects the view of the chairman that this is illegal order, you take corrective measures. Cannot. Therefore, I submitted that it implies directly that you should have withdrawn this. You could not have passed this order again, affirming the earlier order, or in terms of the same order, just passing a fresh order. From that count also it is.
That's it.
One more submission. Well, my contention is that the procedures were not followed or illegally applied. While taking the call, you have to have considered the service record of the employee right from the beginning to the end. But so far, my instruction is there. We have given those records which were considered by only 2 years report. Consideration and form. That lordship will find.
How many years are required?
All entire, what they say, the entire service, they have clarified it in their instruction itself. What you will find. Page number 93. That I was reading that Manohar Lordship has seen about the review committee composition. At page 91. Then Lordship will go a little further. 92, 93.
Road criteria.
Yes, 93, 94, 93. 5. Para 5, 10, 5. Para 10, para 5. The entire service record of a government servant should be considered at the time of review. The expression service record refers to all relevant records, and therefore the review should not be confined to the consideration of the ACR, APAR dossier. The personal file of the government servant may contain valuable material. Simply, his work and performance could also be assessed by looking into files dealt with by him or in any papers or records prepared and submitted by him. It would be useful if the ministry department cadre puts together all the data available about the government servant and prepares a comprehensive brief for consideration of by the review committee. Even uncommunicated remarks in the ACRs, APRs may be taken into consideration. Then they have quoted the judgments of the apex court also, what is public interest, how they should go about, what should be done. It should not be, it is not a penalty. At page 94, I am tempted to cite another paragraph. According to the apex court judgment, they have themselves pointed out. This will be helpful. 11.2. Case of State of Gujarat versus Medbhai Patel, 2001 3 SCC. Honorable Court held that the law relating to compulsory retirement has now crystallized into definite principles, which could be broadly summarized thus. 1. Whenever the service of a public servant are no longer useful to the general administration, the officer can be compulsorily retired for the sake of public interest. 2. Ordinarily, the order of compulsory retirement is not to be treated as a punishment coming under Article 311 of the Constitution. No better administration is necessary. For better administration, it is necessary to stop off the duty. But the order of compulsory retirement can be passed after having due regard to the entire service record of the officer. The Supreme Court has said that basis point is mentioned. Any adverse entries made in the confidential record shall be taken note of and be given due weightage in passing such order. 5. Even uncommunicated entire entries in the confidential record can also be taken into consideration. 6. The order of compulsory retirement shall not be passed as a shortcut to avoid departmental inquiry when such course is more desirable. I will have some submission on this point, my lord, here, how they proceeded. I'll come to kindly note this one. The order of compulsory retirement shall not be passed as a shortcut. Here they have adopted as a shortcut to avoid departmental inquiry when such course is more desirable.
All these arguments will come provided your first argument that
I hope
56(1) or 56(j) is applicable.
or then on. Otherwise, Lordship may not have to deal with it. But I am pointing out because I have prepared my case on these lines also. So I will just bring it to your Lordship. The order of compulsory retirement shall not be passed as a shortcut to avoid departmental inquiry when such course is more desirable. If the officer was given a promotion despite adverse entries made in the confidential record, that is a fact in favor of the officer. compulsory retirement shall not be imposed as a punitive measure. Here also that it is as a punitive measure there. Malafide. Then again 94 TSCC, as Ramachandra Raju's case has been referred to. They have said all this.
Yes. Let us hear the first issue.
Yes. Then
Then we'll proceed. If required.
necessarily I will go to the other part because I have already annexed that on page 99 to page 116. I have shown what is bias here. That they could have taken this call at all. And despite this court's stay order, they proceeded and passed the order.
All right.
Compared to what they similar.
Yes.
My lord, so going at the ground on which this petition has been filed and my reply that the institute is an autonomous body funded by the government of India and it is registered under the Society Registration Act. My lord, and and its employees are categorized on the basis of each pay level.
So he
And-
falls under which category?
A category.
A category.
On the basis of that.
So if he's A category, then the conditions prescribed in 56A will have to be applied.
Yes, my lord, it is specifically mentioned in it is clearly mentioned in the office memorandum 28 August 2020. And the applicability of FR 56J. In this regard, I would like to produce one document 29th August 2024.
First, explain to us 56. What are the conditions for application of 56J? 56J contains two parts, 1 and 2.
Yes, no, my lord. Yes, there are three provisions, my lord.
No.
One, my lord, at page of my affidavit, my lord, affidavit number 242. There are three provisions, my lord.
Why don't you come to the act? I mean, the rules.
My lord, here the who are CCS pension rules under CCS pension and group A officials. They were come, they complete the qualifying service of 30.
Come to the 56J.
56J is applicable to the all government servant
So
and
please read it and enlighten us.
it is
56J.
221, my lord. 221 of my
21, whatever page, we don't know. You were reading 56J. From wherever you want to read it, tell us.
it is a office memorandum government of us.
Why don't you refer to Group 56J?
56J, notwithstanding anything contained in this rule, the appropriate authorities shall, if it is of the opinion that it is in the public interest, so to do so, have the absolute right to retire any government servant by giving him notice of not less than 3 months in writing or 3 months pay allowances in lieu of such notice. If he is in A or Group B service or post in a substantive, quasi permanent or temporary capacity and had entered government service before attaining the age of 35 years. After he has attained the age of 50 years. In any other case, after he has attained the age of 55 years, this is applicable for us.
So he, according to the petitioner, he did not enter government service before 35 years. He entered at
Yes.
42 years.
In any other case,
So any other case will be applicable to Group C.
no, my lord. It is clarified by by the Office Memorandum 28, 2022.
Page number?
Page 242. There are three provisions here. Para 3. Provision relating to premature retirement in the Fundamental Rule and CCS Pension Rules 1972. 3.1. The appropriate authority has the absolute right to retire a government servant under FR 56J and 56 FR 56L or Rule 48(1) of CCS Pension Rule 1972, as the case may be, if it is necessary to do so in the public interest. 3.2. FR 56J. The appropriate authority shall, if it is of the opinion that it is in the public interest to do so, have the absolute right to retire the government servant by giving him notice of not less than 3 months in writing or 3 months' pay and allowance in lieu of such notice. If one is not here, not applicable, because in any other case, after if he is in Group A or Group B service or post in the substantial or quasi-permanent or temporary capacity and had entered government service before attaining the age of 35 years. He entered after 35 years. He has attained
Before
the age of
entering
55.
35 years.
Huh?
Before he enters 35 years.
Before attending.
Before attaining 35 years.
35 years. But he entered into service after 35 years.
Yes. How is it applicable?
In any other case, after he has attained that, this is applicable money too.
This is applicable not to Group A and B.
No money.
In case of Group A and B, it is 1.
Then 56 56L next.
You are not using 56L.
It is for C group.
56L, the order of compulsory retirement is passed under 56L. It is by invoking 56J.
Yeah,
the
but
improved order.
there are three provisions, my lord. It is combined.
No, how can it be combined?
My lord,
56J, 56L, these are all different.
the 56L is applicable in case of C official.
So he is not Group C as per your admission.
Yes. Group. And Group A official under 3.4, Rule 48(1)B and CCS pension rule, who are entitled for pension. Group A officials. They have to complete the qualifying charge.
Mr. Dotto, if you are not making arguments, we will refrain from giving you an audience. You must address the issues which are raised. You have invoked Rule 56J. It has certain conditions. You say that he belongs to Group A. You satisfy us that Group A and these conditions are applicable. You admit that he is not entered government service before 35 years. How is 56J applicable then in case of Group A officers?
Unless he attained the age of 55 years.
The Group 56J also does not apply to 55 years. It says before 35 and after 50. And Group the Roman 2 is for 55 years.
And
Mr. A.K. Dotto, Senior Counsel, assisted by MS also, Mr. A.K. Dotto, and Ms. Tapoti. All
private respondent 4 and 6. Counsel appearing for CBC. Counsel for the petitioner has completed his argument. The liberty to right. Counsel for CBC is permitted to address before the question J. The question of applicability 6J. Serving the writ petitioner. Which will the respondent authorities compulsorily retiring the writ petition. Let this matter be listed again on all right, 17th February. February. It will be. Yeah, 17.
Lordship, in this case, Lordship, only the issue to be decided whether the Deputy Commissioner has the authority to cancel the sale deed. In this regards, Lordship, in the earlier occasion, I have relied on the judgment of the Honorable Supreme Court of the larger bench. Your Lordship will find that issue has been decided by the Honorable Supreme Court. Your Lordship will find at paragraph 13.
We have not had the judgment.
Lordship,
Judgment is not here.
I have already given. I have given all the judgment and
Yes. I want to be here. Yes.
Satyapal Anand case, Lordship, your Lordship will find paragraph 13, issue number D and E. E is specifically whether the sub-register registration had no authority to register the extinguishment deed dated so and so, unilaterally presented by the respondent society for registration. D is there whether the sub-register has authority to cancel the registration of any document, including an extinguishment deed after it is registered. Similarly, whether the Inspector General can cancel the registration of extinguishment deed in exercise of power under section 69 of the Act 1908. Your Lordship will now come to paragraph 21 of the judgment. The role of sub-register starts once the document is registered. The section 17 of the Act 1908 deals with documents which require compulsory registration, and extinguishment deed is one such document referred to in section 17(1)(b). Section 18 of the same Act deals with document registration whereof is optional. Section 20 of the Act deals with documents containing interlineation, blanks, erasures, alteration, and section 21 provides for the description of property and maps or plans, and section 22 deals with the description of house and land by reference to government maps and survey. There is no express provision in the Act of 1908 which empowers the register to recall such registration. The fact whether the document was properly presented for registration cannot be reopened by the register after its registration. The power to cancel registration is a substantive matter. In absence of any express provision in that behalf, it is not open to assume that the sub-register would be competent to cancel the registration of a document in question. Similarly, the power of the Inspector General is limited to do superintendence of the registration office and make rules in that behalf. Even if the Inspector General has no power to cancel the registration of any document which has already been registered. Now, Your Lordship may kindly come to paragraph 25. Here, Lordship, Honorable Supreme Court has clearly says who can cancel the sale, Lordship. Where it, Lordship, paragraph 25. The Andhra Pradesh High Court, in case of Yanala Maleswari, was called upon to consider whether a person can nullify this sale by executing and registering a cancellation deed, and whether the registering authority like district register or the sub-register appointed by the state government is bound to refuse registration when a cancellation deed is presented. The fact remains that if the stipulation contained in the section 1718 of the Act
doesn't require so much of it. It's already a settled law. Once he's registered, he's powerless to cancel it. How is he cancelled?
But it is a larger concern.
That's the law, Mr. Biswas.
Yes, yes.
He has to file a suit for cancellation.
Yes,
Declaration.
will file it, my lord.
Whoever wants to file it,
Yes,
that's a different
that
issue.
is the thing, my lord. At least, my
No,
lord.
merely because
Non-gender of the party is bad.
This
in
will
this
not
case.
no, merely because the person who agrees has not come to the registrar.
My lord.
He cannot assume powers of that person to cancel it. File it.
That
These
part
powers
is-
must be there. Powers must be there.
Yes.
So if
Only
he wants to
thing, my
put-
lord.
if he wants
Last,
to put the other person on notice, it is up to him.
yes. Only thing, my lord. I have also placed some list of deaths. I think, my lord. Short list of deaths. I was
List of dates,
submitting,
not judgments.
not judgment. My lord. Because for proper adjudication of the case, certain things are required to be taken into account.
Like
Number one, my lord.
here, at the end of the day.
Yes,
continue.
some other day. I'll take only 5 minutes time.
Tuesday.
Tuesday, no problem.
Tuesday.
Yes, sir. Only the my humble submission.
But the other
before this
day,
honorable court
he
is
was
that
not in a position to reply as regards the section
That
21A.
the argument should be limited to the limited lordship that the whether the deputy commissioner has the power that has been conferred under the law
And
to exercise
whether there is a NOC required.
that lordship. So far, the legality and genuineness is also concerned. The Honorable Supreme Court, in the case of lordship,
See, first you have to address the facts of the case before
Yes,
you jump to the
that's
judgments.
lordship,
These judgments are rendered only.
this is a part are there for lordship.
No, no, part heard, okay, but you have to refresh that this is what was argued and to the
Lordship,
ground.
in terms of section 20A, 21A of the Registration Assam Amendment Act 2022, your lordship will find if the property has to be sold out along with the lordship erected construction, then lordship in that case power of the deputy commissioner has been seized by the legislature under the Registration Act. Section 21. And subsequent. Here it looks. Nine.
Why are we hearing this matter here? Bench 5 matter.
My lord, lordship, last occasion when your lordship was sitting as, that is why my lord, it was made part hard.
Then we release it.
And Tuesday lordship can
Release,
dispose.
release. No, we have got enough bench matters.
Because lordship has hard blank, my lord.
What can be done? We have to release it.
I think, my lord, lordship should,
So see, the problem is that once the bench changes, then unless this will require some amount of hearing on the count whether the NOC is necessary,
yes.
number one. Number two, whether the DC after
Is
having
empowered.
registered. So
I'll not take, my lord, more than 5 minutes.
no, it's not about 5 minutes.
Right.
It's about how you address the court.
Right.
There are two issues. One is whether the officer who has registered,
Right.
if it is brought to his notice
Right.
that certain mandatory provisions are not complied or there is fraud, is he, even then, is he debarred from cancelling it?
Certainly, my lord.
Should the beneficiary
Declare
be,
without any declaratory
should,
on this.
should the beneficiary be relegated to a civil suit to fight that
Yes.
for years? These are issues you have to argue. You
Yes.
can't do it in 5 minutes.
That is why, my lord, to place my
We'll
case.
release it.
Yes, sir.
You argue with afresh.
My lord,
Because these are issues which you'll have to.
this can be, my lord, I think,
Mr. Counsel, see. Firstly, that DC has cancelled without there being any complaint. Nobody has complained. How you have got the input from
complaint is there, complaint is
by the daughter?
yes.
Then-
Earlier, my lord, in fact, mother gave a part of land to the petitioner number 2, my lord. That was
See,
Uh,
what
No,
was
you
the
argue with
affidavit
before
that has
the
been filed in
competent
Deputy
bench.
Commissioner,
Heard
that is the
counsel from
final
parties.
lordship.
This matter was heard. Last for the last dates. It's fixed today, however, in the meantime, it's the change. This matter is before the appropriate. Registry will ensure the matter be listed. Considering the urgency expressed, registry will ensure the matter be listed in the week beginning from 16th before the appropriate bench.
can it be on 18th?
No, we are saying in the week beginning from 16th.
Oh, all right.
Highly obliged.
This we'll take it up today. The time is over. We'll take it up on Tuesday. Tuesday.
10th of March.
See, that's the problem. We go to 10th of March, we'll forget everything.
Then on 18th, can I?
Not 18th. You choose the date in Tuesday and Thursday. All right, 10th is good for you.